For delivery of project item of 20.
This revision petition stands dismissed.
May have his lordship. My lord, this is bail matter, bail application. It was earlier rejected by my lord Justice Sanjeev Sharma. He is out of station. We have filed the case. So today is the last day. On the other hand, if after opening day, it will be more than statutory
We are
period.
going to list it. Today we are not going to. You can approach register. Your case has already been registered or not? Only file
Yes,
or
case,
register?
it is case number is there.
Then it's registered. Then
Yes.
you immediately approach registry. It may be accommodated. We are not going to list any.
Today is unlisted, my lord.
No, no, at all. Not.
May please, your lordship. I beg to differ. Item number 33, my lord. Notice was issued to the respondent number 2.
33.
Yes, my lord. Service report is awaited, my lord. I have just checked the report, my lord.
When 33 you are.
Yes, my lord.
Service report is awaited for respondent
Respondent number 2. So immediately after the vacation, my lord.
That's right. You see the gun petition. But it awaited. Let the service be awaited. It may be awaited.
It
After
may be,
vacation,
it may be fixed, my lord. As an arson,
28th of January.
28th of January. Prior to that, if possible, my lord, because there is no interim, it's a criminal.
We don't have any. 21 one.
21,
28 one.
21. Hello, guys.
May it please your lordship, I beg to mention item number 17, lordship. Kindly, madam, may be adjourned for the day, lordship. Mr. P.K. Roy, sir, has some personal difficulties, lordship. Immediate after vacation,
What is
lordship.
the position here?
My lord, we have received the case there, my lord. They are interim, my lord. If they take time, my lord, we will have to send back for update.
Otherwise, you have received the case.
Received the case.
Your MS J. Ghosh.
J. Ghosh.
Heart MS J. Ghosh. Heart Distribution. And it is sent PPA. Setting the graph. In this council. Mr. PK. Which already determined rare act. Is submitted by Mr. Sharma as CD receipt. Let the CD be returned. Following an updated one. PST matter. 28 of January.
Obliged.
8-1 interim be continued next.
Lordship, I beg to mention an item that was before this court yesterday, your lordship. It was a BA, your lordship. The date was fixed on 22nd January, but before that, the date for framing of charges are fixed, your lordship. So the client has instructed us to withdraw the bail, otherwise the charge framing would be delayed till the disposal of the bail, your lordship. So I beg that.
You have filed already.
Yes, your lordship. It was before this court yesterday.
You will do the
Today,
will return the matter to the bench, and that's what he is saying. He will just explain
Yes.
what is the
May I please, your lordship. Your lordship, I beg to mention one IA criminal for listing in the month of January, your lordship, after reopening on 7th January, if possible.
IA criminal
IA
in
criminal.
appeal.
Yes, your lordship.
In appeal.
In appeal.
Make a mention before Justice Manichod.
I will.
lordship, as we discussed, can it be taken up today only as production item and we get it withdrawn?
Yes, yes, today.
Polish. Give the instructions to withdraw.
to withdraw this one.
Yes.
Part Mr. has just constituents as best. It will be disposed of in withdraw.
Obliged.
So, item number.
Please, your lordship. 53 VNS's application, lordship, the case may be called for along with the postmortem report, lordship. 1031 is there.
103 is there.
Lordship.
My lord.
CDB call.
38 is in custody, lordship. Protest may be given, lordship. Immediately after the vacation, lordship.
Since when he is in custody?
He was as around 22/11/2025, lordship.
Immediately to
My lord, after Bihu.
after Bihu will do
The Bihu,
22
lordship,
11.
can be after, before Bihu, lordship.
It's very problematic for us now because many matters have.
One chance may be given,
fixed.
lordship.
Pardon?
One chance may be given, lordship, because,
No,
lordship,
chance
this
is different.
Hmm,
thing.
my-
We have to accommodate that. Chance will be,
Yeah,
the chance will come later on. First we have to,
before Bihu, lordship.
that's what I'm saying. Sorry. 19. At best 19, we cannot adjust. 19.
19, lordship, it will be
6 months.
long, lordship.
6 months, maybe about to be 6 months. If long, then you may approach other way. We don't have any. 19-1 CD alone.
I am obliged, lordship.
May I please your lordship? 483 application lordship, third time lordship. Transited case,
Sensitive, lordship may
Transitive.
confirm.
it's from Kamrup Metro lordship. But lordship, in this case, earlier occasion though rejected by the Honorable Court for non-compliance of section 50, we have taken that plea. But that is, lordship, I have gone to hold a record. My lord, that is not in the original record in which is pending before edition number 5. So my humble prayer before this honorable court with a report along with the entire record may be placed before this honorable
What
court
kind of report you are saying?
regarding non-compliance of section 50 or in the order sheet it is reflected that the one council heard accused / council. So my lord, after going through the entire record, we did not find the wakalatnama and engagement of any council lordship. That is where my humble prayer before this honorable court, though it is reflected in the order sheet, it is not in the record. If it is, if any wakalatnama or anything, any advocate was engaged at that particular point of time, at the time of arrest, there must have some authority, my lord. That is why, my lord, all the with the report along with the record, it is necessary.
That means what kind of report you want?
Report means lordship by the officer or the learned trial judge may furnish any report before this honorable court whether any lawyer was present at that particular point of time or not.
Possible.
If anybody, lordship, suppose this file placed before this honorable court, we have engaged by the accused. That is why, lordship, if anybody engaged or engaged by the court from the DLS, that must have to that there should be an order or lordship or any wakalatnama. Matlab, sometimes what happened in the call below, the court of the court master he wrote all these things. Then that after that put the signature by the officer. That procedure is also going on. That is why lordship a report is required whether any council was present.
Possible.
My lord,
I know.
perhaps in the record, my lord, it is revealed, my lord, whether
Yes, and-
someone appeared or lordship. At this stage, lordship may call for record, my lord. If it is there is any dispute, my lord, then lordship may call for report, my lord. At this stage, my lord, lordship may call for as
No,
it is transitive case.
Lordship,
Or if there is any such kind of thing,
Fine.
then not only the scan copy, maybe the entire record, may be,
My lord, my entire record, my lord.
but that will again hamper.
but earlier occasion also and record was before your lordship, but this report was not before your lordship.
But
That-
orders of the
Orders heard accused / advocate. That was there. That may be typographical mistake or like that, Lordship. That is overlooked by the learned trial court.
No, at the time of his production, if
Hmm.
someone
Appeared,
accompanied, we
might-
are not in
hmm.
a position to say whether any wakalatnama was filed on their behalf or not at present, because it is a criminal case, not a civil. Unlike
Lord-
civil is
Mine.
No, but that, my lord, that,
Filing.
my lord,
but one may accompany the accused and may submit. But now at this stage, so it is not possible. It is not possible on the part of the
well, that is where
the court also, because the court is not there now. At
Mm.
presently, most probably court is also changed. So how can one
Report
submit that that particular advocate was present or not? So it
my lord, wakalatnama
is
should be
fine.
there.
was there.
Without the wakalatnama, they cannot, the court below cannot write about the advocate, my lord.
Happens. It will be may accompany with the accused also. The advocate may accompany with the accused, may make submission at the time of production or at the time of the. So during that period, whether
But my lord,
wakalatnama
he
was
has,
there or not,
he
if
has,
there is wakalatnama is there, then you can peruse, or it is from DLSA or anyone. We cannot say at this stage. So such kind of report is not possible to call for. However, we're calling for the case diary. You go through the case diary, entire case diary, or we can at least pass the order, including all wakalatnama, every document.
Minor, minor.
Then
But
maybe strict order may be passed, because court is also not in a position to say anything now,
Mm.
because it has
Mm.
already been changed. The court is not.
my lord,
other
thing
court
is that,
not working.
thing is that entire record before the trial court. That is why my humble submission before this honorable court. If you
So
look at,
we can call for the scan copy of the case record along with every document, including the
Including wakalatnama.
wakalatnama, if any, everything.
Oh.
That can be passed.
Lordship.
Okay.
And also, Lordship, the compliance of section 50 and 50A.
That will come in the record itself. It will.
Compliance of section 50 and 50A will be in the CD only.
Right.
It will come.
Lordship.
Artemis scanner. And
Check.
just this be
Yeah.
distributed within it. However, it's considering the submission,
No,
by
that's it.
that
It was
the
a-
petition, that the
I don't know.
scan copy of the DCR we call for, along with each and every document, annexed along with the, including the wakalatnama,
legally delay logo.
our local CD one, scan copy of the CD also. So we are calling the scan copy of the DCR, including every documents, including the wakalatnama,
Fine.
as well as the scan copy of the case diary.
Fine.
It may serve our purpose.
My humble prayer to take up matter on 10th of January, Lordship, because
Holiday, or
or 8th, Lordship. My lord, because his
not
mother is in is from Kamrup Metro only.
He's saying it is not possible. Actually, already 2025 matters have already been fixed matter. That about the other will come, and that too
Or-
have some the meetings and all. So most probably
Any day before vacation,
Before-
my lord, 9 I will not be available. That is why my lord 8 or 7 like that. Because his mother's condition is so serious, my lord.
at best immediately after Bihu will do on 19th. Otherwise, we don't have any date. In fact, it's very problematic for us also. I
Lordship.
can understand your problems, but
My lord, only my prayer because Lordship, his mother condition so serious. That is why I urgently filed this petition. Otherwise, after vacation, we would have filed. If possible, let's try once.
7 months. 7? Okay, 7.
Deeply obliged, Lordship. Deeply obliged.
With please, your lordship. Lordship, FIR is at page 14.
Page 14.
Page 14, man. The officer in charge, Manipur Police Station, Bongaigaon, my lord. It's regarding a Facebook post, my lord. It's a comment, my lord, passed by the accused person. I am writing to you. Formally reported on 12/11/2025 at about 11:30 a.m. An information was received to the cyber cell Bongaigaon stating that one person, namely Nur Amin Ahmed, that is the petitioner, had posted a SEDI shares an objectionable comment on a Facebook post through his personal account. After receiving the information, the aforesaid person was brought to the Gerukabari police station for examination and inquiry into the matter. During an examination, it was revealed that on 11/11/2025 at around 8:30 a.m. the said person made a seditious objectionable comment on Facebook post through his account, namely Noor Amin Ahmed, having the following URL number. During inquiry, it has to come to light that the accused person has a history of posting such objectionable and inflammatory comments on social media platforms on several occasions. Such activities clearly indicate his intention to promote enmity between different groups within the society, which has caused communal tension and disturbances, thereby endangering the sovereignty and integrity of India. My lord, as per my lord, my instruction, the comment was that ইলেকশনৰ আহিছে চৰকাৰে জড়িত হৈ বোমা দিছে. This only one line, and for that he is already 37 days behind the bar, my. And already the SIM and mobile card has been seized, my lord, which has been reflected at page 16, my lord, para 3.
Where you have annexed that post here?
That was, my lord, already deleted, my lord, as he has informed, my lord. And
But now the police, this from his mobile handset or etc. Police
yes, seized.
retrieve it, I think, na?
Yeah.
It's not here at all.
Yes.
What kind of post was there?
Yes, that only one line, but my lord, in similar another matter in Bongaigaon PS case also, your lordship has fixed for CD on 7th January.
It was similar matter. Here is the cause title was that Parasita wrongly.
Therefore, I has already my lord corrected that cause title was corrected.
Okay, that case, my lord.
And
Two
that
cases
was
are there.
That is fixed on where?
7th January for CD one.
Okay, then. Seven.
23. Oblige.
No, please, Lordship.
Yes.
My lord, it is 483 petition, my lord. It is about stealing, my lord. Page 6, my lord, the FIR. Respectfully beg to state that on 18/11/2025 at about 5:30 p.m. one vehicle bearing number so and say stealing food speedily came and intentionally hit an e-rickshaw at Goroimari Tinali. One passenger of e-rickshaw, namely Chandrakanto Kaman, injured seriously, and the vehicle number so and so fell down in the drain. The thieves were caught with the help of local people, and 4 other thieves were fled away from the place. Presently, Chandrakanto Kaman is under treatment in AMCH. Therefore, my lord, it is stealing, and my lord, the goat was already recovered, my lord. Actually, the stealing things already recovered, my lord. Here, seizure list, my lord, page, my lord, 14. Place of seizure, Saldau opium, date and so and so. Description of seized article: 1 black and 1 white female goat. And
One black and white?
yes, this is the thing, my lord. Article already recovered. My lord, actually, what happened, my lord?
Oh, one goat was there.
Only, yes.
No, my lord.
Goat.
Stealing goat speedily came and intentionally hit a e-rickshaw, my lord. Page 6, my lord.
In renowned car, he was, I mean, this.
Actually, my lord,
Two of them apprehended, my lord. Some of fled away, my lord. Another, Lakshmi kindly page 19, my lord. Rejection order, my lord. 11% page 20, my lord. May I request? Perusal of the case goes to show that the investigation of this case has progressed and there was sufficient incriminating material against the accused person in commission of the alleged offense, and the other involved co-accused are yet to be apprehended. As such, I am of the consider open there is every possibility that thereafter it is considering the all above, I am not intend to grant the privilege of bail to the accused person Muhammad Amir, present petition number, which in at this stage bail petition rejected. After perusal of the CD matter, getting sufficient material matter, it was rejected. And he was arrested only on 12/12.
31 days.
When arrested?
Three,
He was arrested on?
18/11/2020.
Here it is mentioned on 12/12
Huh?
in the page 1.
No.
Muhammad Amin say,
Yes,
the petitioner,
yes.
in the first page, was written.
No. 12.
As on-
24
as
days
on-
as on 12.
As on
My lord, it is totally false, my lord. I have stated in my in para 3, para 6, page 3, my lord. The real fact, my lord, like this, my lord, that is that the petitioner is 24 years old, young Muslim person. Along with his 5 other young Muslim friends went for a picnic to Sawadwa by a car. Being number so and so one returned, they were stopped their car at Goroimari Tinali to take a betel nut. Some young man having so and so communal feelings attacked them and they started to assault them. On fearing, my lord, some other man who accompanied with the present petitioner, my lord, they fled.
My lord,
This was the fact, my lord.
at present, my
Yeah,
lord, some luxurious vehicles also used for
My
stealing.
lord,
goods
they
for-
went for picnic, my lord. Kindly see,
Ah,
went for picnic by this car. Thereafter, on the return journey,
They have taken
this,
the gold.
So
yes,
why you have brought all this statement in your para 6? Take battle nuts, some young man having.
my lord, as per information, my lord, as the petitioner informed, what happened, how they,
You are an advocate, na?
when I asked them, when they went, and how they have
You
come.
are an advocate, so this kind of comments why you have made in your petition itself.
My lord, as per
You made some
instruction, no?
My lord.
statement here in petition itself.
So,
Not. You made this statement, na?
Not
It's a
necessarily that
statement
part.
you have made.
but,
Maybe there is.
they
I
instruct,
won't disagree with you. Repeatedly, you are saying that you are a Muslim, going with a Muslim
As
friends,
this
and
method,
making
my lord.
so and so.
And attacked, my lord,
Hmm.
communal feeling, my lord.
so yeah, this is my lord, city will call for my lord. After city, after perusal of the record, what to come. They let the city be placed.
Death para should not be there in the petition.
That's what I'm saying.
Para 6.
Yes.
Para 6,
You have mentioned several things.
mention all these things.
Yes.
Anyway,
My lord.
It-
City, my lord.
City will be. 31 days he is in.
21 days already. You already. 8 of
Eight.
January. 8 January.
It is too long. My lord, 5.
Five CD won't reach.
In Lakhimpur.
I mean, CD may not reach. That's why I'm saying. Maybe at best 6 also possibility is very less. Okay, then maybe on 6 then. If you are
6.
24. Hello. Hello. May I please tell us?
Well, in this case, my lord, we are seeking bail today itself, and because of that, my lord, the merits, ground, and the circumstances. So kindly see the FIR, my lord, page 14.
Yes.
May I read? Respectfully submits that after performing Zumma prayer on Friday on 24/10/2025, in the context of altercation held at mosque while going across the path and while reaching in front of the house, the aforementioned accused person, they accompanied with other accused person out of earlier vengeance armed with dao stick and other weapons attack for which aforesaid complainant sustained injuries. Due to blood injuries, the situation became worsened. It is revealed that the accused number 3 often move with sharp knife, which creates tension among us. So it is therefore prayed that before the kindly investigate the matter. This FIR lodged on 4/11/2025. And on 4/11/2025, it was lost. And at night, my lord, suddenly police visited our house, and we, the father and 2 sons, have been picked up. The FIR was lodged on 24. Incident occurred on 24/10/2025, and the FIR lodged on 4/11/2025. Now, my lord, yes, 4/11.
24/10.
After 10 days, my lord. After 10 days, the FIR is filed. And my lord, the delay is not explained and nothing is mentioned in respect of delay in the FIR, my lord. Nothing is mentioned. Now, my lord, kindly see, immediately, my lord, we were picked up by police and we are also suspect about the act of police. My lord. Now, immediately, my lord, we have filed also FIR, page 24, my lord. Kindly see the our FIR, my lord.
Yes.
Respectfully submit that on 24/10/2025 at about 1:30 p.m., I, along with my father Gyashuddin, brother and nephews, after performing namaz, returning from mosque towards home, suddenly the aforesaid accused person, in a pre-planned manner, resisted us and attacked. The accused number 2 attacked me with sharp weapon, for which I sustained injuries at my nose and eyes. Accused number 1 attacked my father at head with stick, for which he received injuries, and he is now under treatment at Silchar Medical College and Hospital. Thereafter, the accused person attacked my brother Shatabuddin, nephew Anwar Hussain, and brother Joshimuddin, for which they sustained injuries. On being aggrieved of the act of the accused person, I, having no other alternative, filed this complaint before your authority. This affair is lodged on 5/11, my lord. So, incident regarding 24/10/2025 at mosque. There was an altercation at mosque during the Zumma prayer. It was on Friday prayer, my lord.
Just
Now-
tell us one thing, they have lost the FIR after some 9 days.
10 days.
Sorry, 10 days.
After 10 days.
And why you are waiting also?
I am also waiting because what happened, my lord? I am coming on that. Because and for which, my lord, both the persons, both sides of the were arrested, my lord. We are waiting because it was, my lord, what happened, my lord. Kindly see, my lord, my grounds, my lord. Why I am waiting, everything I have narrated, my lord. Kindly see, my lord, page 4, para 5, my lord. May I read, my lord? Page 4, para 5. That the petitioners beg to state that the allegations leveled against the petitioner are false and fictitious. The informants wanted to use the mosque loudspeaker apart from religious tasks. This is the issue, my lord. The said demand was not fulfilled by the masjid committee, for which the informants created chaos in the masjid premises and exchanged altercation. The said act was settled on intervention by the elderly villagers. However, on non-fulfilling the demand, the informants, armed with dao, lathi, and sharp weapon, attacked the petitioners in a very planned manner in the path. As both sides are residing in nearby houses, as the informant side got advantage to attack the petitioners. Now, my lord, para 6. That the petitioner begs to state that they were severely injured by the assault of the informant. Out of all the petitioner, one of them is 71 years old. All petitioners sustained severe injuries. To get recovered, the petitioner got admitted at SMCH. The petitioner number 1, Gyashuddin, got admitted on 25/10/2025 and remained at IPD patient till 29/10/2025. The medical reports and the photographs annexed here which sustained his injuries. The petitioner number 2, Shatabuddin, got severe injury on assault of the informant. He got treated at first by the local hospital, for which he was referred to SMCH. A copy of the medical records and photographs are annexed here to sustain injuries. The petitioner number 3, Shamim Akhtar, also treated first local hospital, later sent to SMCH, where he got treated. The medical records substantiated his injuries. Another boy named Anwar Hussain got severely injured on attack by the informants. However, since he is under 18 years of age, his name was not erased as an accused. Now, my lord, that the petitioner begs to
Yes, I
state.
have to read all the, my lord.
My lord.
Petition, my lord.
Yes, okay then.
My lord.
Yes,
So
okay.
it's
My
a
humble submission is that, my lord, kindly have a look. We are in 44 days in jail, my lord. 72 years old man, my lord, and along with 2 sons. What happened, my lord? This is an altercation took place regarding the Masjid committee
You
decision.
got arrested on when? 5
On 5/11, my lord. So my humble submission, my lord, this after 10 days, both parties filed FIR because that Masjid committee situation, that issue was settled by the learned villagers, my lord. So we don't know whether they will attack again. So they have attacked, but that issue was settled. After 10 days, my lord, they filed FIR. After 10 days, the issue is already been settled. After 10 days, they filed FIR. So we are instructed that we have, because they attacked us. And we were told that since the matters related to the timetable of the prayer, so it should not be go further, my lord. So matter was settled. However, they filed FIR for which we are compelled to file FIR also. So it is only the petitioner, that the informant, my lord, they are very influential person and very having the muscle power. So my lord, they filed this FIR in a pre-planned manner, and their intention to keep us inside in the jail, my lord. So even their intention is fulfilled. We are in 44 days in custody, my lord.
And
Even I'm sorry.
they are also in custody.
No, they have been released on bail, man. They have been released because they know how to manage police. There are something I should not be told before this court, my lord. They know what to do and what not to do. We are, my lord, laymen in this regard because we are related, we are connected to the mosque committee, so we have been targeted, my lord. So kindly, my lord, 44 days in custody, already we have been left, my lord. So under such circumstances, should I?
My lord, here, my lord, I have found, my lord, in the, although there is a, my lord, delay filing not mentioned about this, but injured also, my lord, from the FIR evidence, my lord. Lordship may call for CD, my lord, along with the injury report, my lord. And here is the, my lord, 1182 is there, my lord. That's a grievous.
My lord, my lord, we have gone through the FIR. The delay is not there because the issue is certain.
Mr. H.
My lord, kindly say, my lord.
It's an application submitted by Mr. Chocolate and submitted by the cycles or complete says that there was a took place was it committee website it on but it said that caused people different petitions. It was and that was set by the intervention of some elderly people, which the petitioner side also did not any case against it. Even after the settlement, they lost the effect for which the petitioner side was also found lodge a case against the present petitioner against the informant side, which is also raised. However, the petitioners are behind the bar. It's 511. It's constant their detention. They may be released. The petitioners being the will extend their cooperation. To shortly learn that hereby it's see that the victim sustained regret in their person. Mainly that CD will be that case. Hearing this submission without going to the interpretation. Satisfaction has to be
Satisfaction of CGM Sribhumi.
CGM.
Mild. Bless you.
25. Please, Your Lordship, my lord. My lord, this is a 483 bill application, my lord. Lordship will kindly see the FIR at page 11, my lord. My lord, there are altogether 9 accused persons, my lord, and I am a school teacher, my lord. There is an allegation of, my lord, having some, my lord, physical assault, my lord. And from the 9 accused persons, my lord, I do not belong to, my lord, any of the accused persons. May I read the FIR, my lord, if possible?
You are not the accused.
Not the accused, my lord. Even there is no specific allegation against me, my lord. I'm a school teacher. I was all along discharging my duty as a teacher, my lord. And my lord, I was called by the, my lord, concerned police station. I cooperated with the police, my lord. On 10th of, my lord, December, my lord, I went to the police station. They inquired about, my lord, this accused number 1, my lord, who happens to be my brother-in-law, my lord. There was a distribution of, my lord, around the forms, my lord. In the BDO office, my lord, he called a meeting, my lord. And this, my lord, informant, my lord, he along with his other partners, my lord,
they illegally entered into the office of my lord, this BDO, my lord. And accordingly, my lord, some exchange of words took place, my lord. That is the only incident, my lord. My lord will kindly have a look, my lord, the second paragraph of the affair, my lord, in the page 12, my lord. This will be very clear, my lord. It is mentioned that by disobeying the direction of the present government, the block of development
Yes,
officer
please.
sitting along with husbands of members of Anchalik Panchayat and guardians discussed about the various schemes of government. It is suspected by us against the BDO and the said accused persons that upon our protest to said action, the aforesaid plan of physical assault was made in garage. And I do not belong to, my lord, any of the accused persons, my lord. I'm not a named accused even, my lord. Yes, allegation is upon the, my lord, the accused, same, my lord, altogether 9 accused persons, my lord. The allegation is also very specific. In the first paragraph also, if I may read, my lord, humble submission is that on 1/1/2025 at about 1:30 p.m., when I, along with my partners, were coming out from the office of the block development officer, Nizding, the aforesaid accused persons, with pre-plan came in group with the objective to kill us, obstructed us, and started scolding with foul language and physically assaulted and injured me and my partners, namely so and so, so and so, and so and so. And they also snatched away money bag, watch, and footwear. The accused persons did not stop till then, and they strangled my partner so and so with gamusa and dragged him away, confined him in room, and tried to kill him. Thereafter, my partners were confined in a room, and from that condition, the police rescued us from the place of occurrence and saved our lives. Now, this accused number 1, my lord, is Saddam Hussein, my lord. He is, my lord, my brother-in-law, my lord. And he is the, my lord, husband of, my lord, one of the members of the Anchalik Panchayat group. And the allegation is against him, my lord. And my house is, my lord, situated nearby his house, my lord. When police went to in search of him, my lord, they did not found, my lord, this Saddam Hussein, and accordingly they entered into my, my lord, premise, my lord. I was asked to, my lord, cooperate in the police station, and accordingly I was called upon to visit the police station, my lord, on 10th of, my lord, December, my lord. I visited the police station. I cooperated with them, my lord. And again I was, my lord, allowed to go home, my lord. Then again I was called, my lord, on to be present on 14th of, my lord, December, my lord. And on that day when I went there, my lord, police had interrogated me and they took me in custody, my lord. I'll take your lordship to, my lord, page 19, my lord, in this regard, my lord. There is a certificate, my lord, issued by the concerned headmaster of the school, my lord. The alleged incident, my lord, was supposed to be, my lord, took place, my lord, at noon, my lord, at 1:30 p.m., my lord. Whereas, my lord, it is hereby certified that Muhammad so and so, son of late so and so, village so and so, district so and so. He is a tutor teacher of number 1 Kanthulimari Upper Primary School. On 1/12/2025, he was present in the school on time and imparted classes, my lord.
Yes, sure.
This is the story, my lord. So, my
My lord, here,
my arrest is absolutely illegal, my lord. I have no involvement, my lord.
Lordship, may kindly peruse the page annexure to, my lord, page 16, my lord, forwarding, my lord. Forwarding report, my lord. Here, grounds of arrest, my lord. Para 2, my lord. As per statement of the witnesses that the accused involved in the crime on the day of incident. Secondly, the arrested accused persons along with his partner of the FIR accused has been swearing with obscene words and forcefully dragging away complainants and his colleagues' money bag, watch and shoes. And again, the accused person along with his partner of FIR accused has been strangled with gamusa around neck and confined trapped in the room with the intent to kill of the Pranjal colleague. That is again.
My lord, the allegation is against the accused persons, my lord. I am not, my lord, none of the accused, my lord. I do not belong to, my lord, that category.
You are present in the
My lord, this has hampered, my lord, my service career even, my lord. This is absolutely illegal, my lord. This case, my lord, doesn't warrant, my lord.
Well,
Then calling of CD, my lord, is not required, my lord. Yes, my lord.
7/1,
7/1.
2020.
When
7/1.
please.
26.
Happy to 482 petition, my lord, initiated on the basis of a zero FIR, my lord. The informant, the victim, and the petitioner from Saudia, my lord. Initially, the case was filed before the Saudia police station at page 22 of civil C, my lord. Thereafter, it was transferred to the jurisdictional police station Zone I, my lord. Pasted into the vernacular version. Married. সন্মান সহকাৰে জনাও যে মোৰ ছোৱালী ষ্টেঞ্চৰ বয়স 16 বছৰ, stated as 16 years. Resident of Stench of Saudia, জুনাই মহিলা মহাবিদ্যালয়ৰ এগৰাকী ছাত্ৰী। মই তাই তাতে ভাড়া ঘৰত থাকে। যোৱা ইংৰাজী 31/10/2025 তাৰিখে there was laws on 311 মেলত প্ৰায় 3:30 বজাত অমৰপুৰ নিবাসী শ্ৰী দিগন্ত পেগুৱে ধেমাজি জিলাৰ মুকক চেলেঙত থকা মোৰ ছোৱালীৰ ভাড়া ঘৰলৈ গৈ জোৰ জবৰদস্তি কৰি বাইকত উঠাই নিজান ঠাইলৈ লৈ যায় আৰু তাতে বলপূৰ্বকভাৱে it is the allegation, madam. The petitioner from Hodia and the informant also, Milad. He is a school teacher at Hodia, Milad. I have also an identity card at page 24 issued by the Deputy Inspector of Schools, Milad. The alleged victim, she studies at Jonai, Milad. Milad, allegation that he came all along from
The case is registered under 64(1).
64, Milad. That there is a note by the Jonai police, Milad. Lordship will see at page
Page
16, Milad. Since there is no documents as regards the age, Milad, he is a college-going student, Milad. That case has been registered only against under section 64(1) BNS.
The college going student, no document.
Milad, that is the note of the police officer, Milad, at page 16, Milad. Column number 12.
My lord, it was zero FIR filed, my lord.
Yes,
First, after their investigation, it will come up, my lord.
Milad,
Once
Lordship may call for this.
I'm saying, I don't know
Yes,
about the
Yes,
other.
Milad,
but the
Lordship
question is
will.
that privacy, it seems that the age of the girl is stated to be 16 years.
But she is a
And it-
college-going student.
Maybe.
Well, maybe in the higher secondary also.
Maybe, Milad, maybe. I don't know.
Now it is.
At this stage, it is difficult to say unless the document
Hmm.
comes from the police
It
officer.
will come
Yes,
with CD, my lord.
Lordship may call for the CD, Milad. Only difficulty is he is a teacher in this provincial school, Milad. Some protection, Milad. If
Protection now, I will also just perusing the case, record.
yes, Milad.
But the question is that the allegation is very serious.
My
because
lord.
both nights
Allegation
he
is
was
very
kept
serious,
in
my
a
lord.
room and
Apparently, Milad.
waited.
But the allegation, your Lordship will see, he resides in at Saudia. The school opening day, I have to check, Milad. He was discharging his duties at Saudia at the same time that incident took place at Jonai, Milad. There is distance, Milad.
Whether he was present in the school at that time
My
or
lord,
not.
my lord, that
is
will
not
come in the
question.
CD. That will come in the CD. Some protection, if anything reveals in the case
It's
diary, my
not
lord.
protection. Otherwise, I generally give some protection.
My
but
lord,
the question is that
If anything
this is
reveals in the
not-
CD, my lord,
not
your Lordship,
giving protection. The FIR says a very different.
I understand. I understand. I understand.
Okay, we are calling for the case diary.
My lord.
Are you AB hall? AB hall 8.
Well,
Open it both. আমি করে দিই।
If anything comes in CD and POCSO will be added, my lord, I'll have to withdraw this case, but otherwise I'll have to amend the petition.
My probability of coming POCSO is
My-
very
my-
there. That is why.
Otherwise, my lord.
Otherwise, anyway, we are fixing it on 8/1/26. In the
Obvious.
meantime, it may be there, may not be there. Also,
Mild.
I know.
Obvious.
In this case, my lord, a land dispute, my lord, is fabricated in a different manner. My lord, kindly see the FIR, my lord. Page 11 is the FIR, my lord. Respectfully begs to state that the accused persons are the resident of our village. The accused person, out of vengeance, attempted to kill my maternal uncle Arifuddin. Under such circumstances, on 22/11/2025, in the evening at about 3:30 p.m., my maternal uncle Arifuddin was scrolling his mobile phone under a tree in the bank of the Shonbil Westland, my lord, bill. While seeing Arifuddin alone, the accused person armed with dao, lathi and iron rod conjointly attacked Arifuddin. When accused number given a blow with dao, his head sustained severe injury. The accused number 3 gave blow with iron rod for which Arifuddin sustained severe injury in hand. The accused number 2 caught Arifuddin and helped the other accused person to assault. When Arifuddin raised alarm, then surrounding persons, including gathered here, including me, my lord, the petitioner informant, gathered here, there, for which the accused person fled away. At that time, I was grazing my cows. On reaching Arifuddin, the accused person snatched away cash amount of ₹20,000 from Arifuddin. At present, Arifuddin is under treatment. This is the FIR, my lord. Now, my lord, kindly see for a moment, my lord, kindly see page 3, my lord, para 3 of this land dispute is converted into an FIR.
That's enough
That the
proceeding.
petitioner, my lord, just I would like to mention this. Just the petitioner begs to state that the allegations leveled against the petitioner are false and fictitious. The FIR is lodged by hiding the real incident. The petitioners and the informant are having land dispute. The land in dispute is situated in the bank of the Shonville, a wasteland. That land is very fertile and it is situated on the bank of the Bill. The petitioners are cultivating crops in this suitable season. The informants, along with his maternal uncle Arifuddin,
You
and
are the gathered person. You are the FIR named accused number
My lord,
1.
all
Yes,
of them apparently.
this is right. For all of them, my
All of
lord,
them are
we
fine.
are the brothers, my lord, from the same family,
You may be brother.
not
I see.
gathered anything, including in respect, my lord, they gathered in that particular area. And we were cultivating the crops, my lord, on the bank of the Shonville. And the issue is there, my lord. May I read, my lord, continue?
Lordship,
Because that picture will be cleared, my lord. If I read, my
We are
It is
calling
the
for the case diary.
AB, my lord.
Call for
at least
At least 19.
19.
my humble submission, my lord, the BLO is visiting, my lord. Due to BLO, our name is not entered in the, my lord, SR, in the division, my lord, because we are not there, my lord. If the interim is granted, my lord, our name may be entered
We are
in the,
fixing it on
No,
19.
no, this is not the case.
otherwise, my lord, we may be suffered in this way, my lord.
It is on your case.
May I please your love? Item 6, my lord, in this case, my lord, may I read, my lord, kindly see the FIR.
Mm.
The FIR is lodged under section 87 BNS, my lord. 87 BNS, and my lord, kindly see page 8, my lord, FIR. I am Niazuddin, son of Abdul Matin, resident of village so-and-so. My daughter Tasnim Kausar, a student of HS first year Central Public School, age 15 years, 11 months, 15 days. On 2/7/2025, my daughter went to school but did not return. I and my family, after doing ample effort, is able to know that one Zabir Hussain, son of Manozir Ali of Dualia, Part 2 under Patargandhi PS, kidnapped my daughter and taken away. On knowing the incident, I immediately approached his father, Manozir Ali. He assured me that upon rescuing the daughter, he handed over my daughter to my family. Unfortunately, after passing about 12 hours, the father and son informed me that he failed to trace out his son. So this is a missing report. Generally, missing FIR is filed. Now, my lord, kindly see this. Both girl and boy went out and later they again came back to family. Page 3, para 3, my lord.
No, this is your case. Whether she is recovered?
Recovered, my lord. Recovered.
Where from your say?
My lord, page 3, my lord, para 3, kindly see.
This is your information.
My lord,
Your
everything.
statement. I'm saying whether there is any note of the court or her statement recorded. Is there any?
Her statement is recorded. He recovered. Everything is there. My lord, my humble submission, case there may be called for. By this time, I may be protected. Because
No, where is the recovery note?
the recovery note, my lord, I cannot annex, my lord. It is on the case record.
This is your case. That is, you have been
This is
recovered.
right, my lord.
And I can understand that
Yes.
this 16 years girl may have a love affair with the boy.
Yes, ma'am.
He's
Yes.
not disagreeing with you.
Yes.
But the question is that a case of kidnapping is there.
Yes.
What happened to the girl?
My
is
lord,
not
later on.
known to us. It is your statement only.
Yes.
That you made this statement that the girl is recovered. Now they so and so. They may be love affairs. I won't disagree with. But from where we are saying, if she has been recovered, suppose 164, then it may be case would have been different.
Yes.
But now it is your statement only that they cared.
Because
After her recovery, she was produced before any court.
yes, my lord.
So why don't you take
That
up
order is
separate
maybe
My lord, so far my knowledge is concerned, she approached before the police. She stated before police, and she is now with her father, my lord.
It's okay.
So-
Whether her statement recorded,
Statement so far, I know, my lord, it is recorded, my lord. Statement is
then
recorded.
you could have produced this before us.
My humble submission is that, my lord. Case diary may be called for. Everything will be in the case diary. By this time, I am protected.
No, no, not
What happened, my lord?
21,
Because
2021.
my lord.
my humble submission is that it is because everything is settled. Both the parents.
I can still,
How said you?
I'm
It is
still with
15
you.
years
I
old,
I
my
can
lord.
understand.
Yeah,
The
my lord.
question is to give up some report. Otherwise, it may be a case for anticipatory. I would disagree with you because love affairs, he may they may go for a walk also. Everything can happen. I'm not disagreeing.
Well, my
But you
statement,
just give
my
us
statement will
something
not
at
be
least.
countered by the case diary, my lord. It will be supported by the case diary. What I am saying that
No.
Yeah.
You could have produced something before this court today. At least her recovery could have been ascertained. Now there is nothing before
Hello.
us at present to come to know whether she was recovered, her statement recorded, or what was her statement. These are not before us.
my sub,
You may not be available. You may not get the certified copy of your 164 or one,
Yeah.
but at least her recovery that could have been produced before us. That's what I'm saying. Okay, we're fixing it on 20/01/2026 for CT.
protection will be given, my lord.
No, sorry. That,
But I am seeking protection, my lord.
no,
My lord.
sorry.
Obliged.
What I decided. City, my lord, 21.
Yes, 20.
May I please, Your Lordship? This
Yes.
is for, it is to application for granting praise bill, my lord, under section 109, my lord. Actually, there is a group fighting between two parties, my lord. And altogether there are 16 petitioners, my lord, accused petitioners, my lord, and there is a cross FIR also, my lord. So may I pray for protection, my lord, at least that 60 years man, my lord. That the petitioner number 1, my lord.
Petition number 1 is
One man.
here.
60 years, man. I'm praying for him only, my lord. Other case they may be called for, my lord. He was not there also, my lord. The group fighting and house trespass also, my lord.
How many persons injured? Got injured because there is very
Yes.
serious nature of case.
My
Yes,
lord.
my lord.
ভাই মুশারফ আগবাঢ়ি অহাত মাৰপিট কৰি
109 is there,
One
118
hand
is
has,
there.
one hand finger has been cut off, my lord.
yes,
Yes,
and
ma'am.
this
They're using
he
dao and
also
all.
hits serious head injury was also there.
My lord. I'm praying for this item, petition
One
number
only.
1, my lord. 1 is 60 years, my lord.
I don't know if he is the
My lord.
culprit.
No, my lord.
Age may
He
be
was not
60,
there
but
in the place of occurrence, my lord.
Huh?
As per instruction, my lord, he was not there, my lord. But that because of the names are all same, that's why, my lord.
All names same.
Yes, my lord, almost same, my lord. That's why. As per instruction, my lord, that's it.
Almost same.
And no, 109 Beneswell is there, my lord.
He says
That's the 10
109
years.
is there only.
Yes, my lord. Others are 7 years punishment.
Part Mr. D. Bora, the done it. Part Mr. B. Sharma, the done it. It's an application, section so and so, so and so. Considering the submission made by the counsel for petition, Mr. Bora, and only considering the age of the petitioner number one, he is provided with some interim protection. How prayer for interim protection for the other petitioners, that is the petition number 3, 5, 6, 7, 8, 9, 10, 11,
7.
79, not considered as CDB
my lord.
be listed.
My lord, my submission is that city may be called for, my lord, as injuries in the grievous in nature, my lord. And 109 attempt to
Yes,
murder.
109 is there, my lord.
And 1182 grievous hurt. What the grievous death are there.
Mr. Sharma pointed that we have to accept that cases of serious in nature that the victim sustained grievous injury and there was an attempt of accordingly insisted. Okay, we are giving protection only one considering his age and when it can be called for.
Well, after Bihu, my lord.
This obviously after be
My lord.
Any date, my lord.
28.
20. Obvious, my lord.
CDN injury report. my lord.
yes, CDN.
And case there are both the cases, my lord. That cross FIR also.
No, no, not necessary.
Yes, my lord. Obvious.
A tragic incident has happened, my lord. That page, my lord, 15 is a FIR, my lord.
15.
Yes, my lord. Section 108 is acted, my lord. May I read, my lord?
Yes.
This is to inform you that on 21/11, the FIR has been filed on 2/12/25, my lord, and the incident is of 21/11, my lord. This is to inform you that on 21/11/25 in the morning at around 9:45 AM to 10:30 AM, my daughter so and so in her own house without knowledge of the family committed suicide by hanging. When informed about the matter, the police personnel has taken necessary steps. In the meantime, by our own investigation, we came to know the accused was having an affair with the deceased daughter, and the accused has compelled my daughter to the extreme step. Kindly see the incident was happened on 21/11/25, my lord. And there is no explanation, my lord, why the delay has been caused, my lord. And there is no allegation, my lord, that I have harassed the victim also, my lord. Even no allegation. Yes, my lord.
I mean, there may not be in detail, but there is the allegation that
Yes, my lord.
due to
But admittedly,
your
there is a love affair with the, my lord, the victim, lady, my lord.
Huh.
Now I have explained para 4, my lord, what actually happened, my lord. The petition is 21 is boy, my lord. Page 4, my lord. Para 4, my lord.
page 4.
Page 4, para 4, my lord.
Yes.
Mary, my lord. The accused person in no way connected with the alleged offense. However, the police person are in so and so. The real fact of the case is that the accused and the deceased were involved in affairs since the month of April 25. The deceased was a student of class 12. It is said the family member of the accused petitioner objected their relationship on the ground the deceased and the accused are not from the same caste. Situated, the accused petitioner tried to make the deceased understand that the relation has no future and therefore he wind up all a relationship of the deceased. However, deceased did not accept the same and insisted the accused petitioner to continue the so-and-so and tried to force him to live with the so-and-so. In fact, threatened him to kill herself if the accused petitioner does not continue the relationship. I have annexed some of the personal the WhatsApp message which shows how the whether the victim was hypersensitive or not, page 80 annex 3 I got in page 18
Okay.
But can you see the sentence start from you you just cut all my face. Just remember not to
There.
I mean relying on judgment under what circumstances the abatement is has to be attributed,
See, this is your case that they have a love relationship.
Yes, madam. Admittedly, madam, the
It is not
yes, madam.
disputed,
The FIR also is states, madam.
but how she got earlier whether there was any kind of not harassment. In fact, what was her compulsion or how
Yes, madam.
she
But
and
if,
whether he because the
but human
FIR
behavior,
says
madam,
you are
very from
your you only compel her to take such extreme steps.
yes, madam. Whether there is a
Young girl of
yes, obviously, madam.
student of class 12.
The petitioner is also 20 years boy, madam.
Yes. So otherwise this will come. This definitely this will come. But the question is that now we do not know anything.
Yes,
Because, so let the
This is
case
a
be
these are my last message, madam. That's why, madam.
going to case diary.
Yes, madam.
Because
In the
it is a
meantime,
case
madam,
of
because madam,
suicide, interim cannot be. Yes, Sharma is there.
My lord, I pray for shortcut, my lord, to produce the case there, my lord. Interim not at this stage, my lord. My submission is also there, my lord. And
he is not.
here the-
He strongly objected, madam.
no, that is not. I cannot say to allow him to go on bail, my lord. This is not my submission, my lord. I am saying from the FIR, my lord. What happened, my lord? If he is not, he have no any, my lord, knowledge or any involvement, my lord, how his name will be given in the specific name in the FIR, my lord? Something is there, my lord.
Parents most probably gave her
My
gave
lord.
him because they were knew about the relationship between
My
them.
lord, my lord. That is also
So
in. They have also said that.
there
that
is an
is-
apprehension that for that reason only she committed suicide.
My lord.
When between he produced some this conversation between
ma'am.
them through WhatsApp or the messages. So that is there, but say, better to call for the case diary.
In the minda, I pray, my lord.
Art Mr. Khan Koidum, very good call for case diary. Immediately after vacation, 7-1,
My lord.
7
Okay, can I pray for interim, my lord, in the meantime?
7-1. Right.
Your Lordship. Three years by Lordships. Petitioner is a my lord cricketer of Assam cricket team Lordship.
Some cricket.
Cricket team Lordship. Actually, allegation is that my lord he approaches his teammates, two teammates to involved in some such fixing Lordships. But that two player Lordship.
So match fixing.
Lordship.
Acha.
That two players inform the captain Lordships that the allegation is raised. My lord, my humble son is that offense has not been taken place Lordships. As per allegation Lordship, only he intimated his two teammates Lordships by WhatsApp, through WhatsApp Lordship. Offense has not been taken place. My submission is that some rivalry is there in my team Lordship. So some of my rivalry teammate maybe raise this allegation against me Lordship. So I want to appear with the police. I want to discuss everything Lordships. So CD may be called for in the I may be protected. My lord.
Yes.
I am a
My lord.
player Lordship.
Here, my lord. Here again, I will have to object, my lord. Here is the. It was filed by the Assam Cricket Association, my lord. And some here is the allegation against that, my lord. He along with two others, my lord.
My offense has not been taken
Involved in
place.
this offense, my lord.
Offense only.
Fixing, my lord. Lordship may call for CD at this stage, my lord.
His
This
name
is my
there
lord.
in fact.
No, my lord. Their names are,
My lord,
and they also
cheating and
suspended from the
criminal conspiracy.
newspaper. I have also found they were suspended from the Assam Cricket, my lord.
That's why I want to appear before the police Lordship because
There-
offense has not been taken. Only my allegation is that I have sent some WhatsApp messages and that is reported to the captain Lordship. Only that much, nothing else, my lord. So my lord, offense cannot be.
Earlier also you were.
No, Lordship, nothing. No allegation is there earlier Lordship. Only this is this time Lordship. So definitely I have some rivalry in my team Lordship. They may have some conspiracy against me, my Lordship. So I am facing the trouble Lordship right now, my Lordship.
But WhatsApp message was sent to him, by the
That's why I want to my lord, I want to disclose to the police Lordship what I have done, what is to be done, Lordship. So my lord, some protection may be granted. I want to appear before police Lordship. So and allegation only my lord criminal conspiracy and cheating Lordship. Punishment is one is bailable Lordship and another is non-bailable. So maximum punishment is 5 years. So my lord, that only I am a cricketer Lordship. So my career is here.
Go for such corrupt practice.
No, nothing. That's why I want to appear before. No. So my lord, that's why I am.
They are the rising stars of our Assam, my lord.
Yes.
But
My
they
lord,
have done.
that is why I want to
Keep
appear
this
before the police Lordships. I want to participate in the investigation Lordships. So my lord,
Now?
some protection may be granted
Okay,
Lordships.
then we are calling for the case diary based on when it can be.
Well, protection kindly because
When it can be listed.
My lord. 8, my lord. 8, well.
8-1.
protection my lord.
No protection.
May I please your lordship?
Yes.
Application under my lord 482, my lord. Here in this case, my lord, arising out of same FIR, my lord, other co-accused was granted bail by this honorable court. There is an order, my lord.
Urging it up.
Regarding my lord, Namti PS case number 16, my lord. Here in this case, my lord,
No, that was the
upon the
case
state,
was different. Now,
no,
different
here,
issue now.
upon the statement made by the main accused, my lord,
Ah.
I was implicated in this case, my lord. This is the same ground, my lord.
No, this case is,
In the FIR, my lord,
your case is not similar with your co-petitioner. What is your case, I'm saying?
my lord,
Yes.
3 persons were arrested, my lord. And upon their
Where is the FIR?
FIR said page 15, my lord.
Page 15.
15.
Very long FIR. Anyway,
My lord, these 3 persons, Noor Muhammad, Motibur Rahman, and Nasim Wahid, they are arrested, my lord. The matter regards to the cattle theft. And upon their statement, my lord,
you are Hafizur.
Hafizum.
My lord, basically what has happened, 3 persons were arrested. They were cattle theft, my lord. Public arrested them, my lord. During from there, my lord, some materials were recovered. Then they stated that, my lord, they came to that place to purchase the cows from this person, my lord, the petitioner, who is the mastermind of this basic gang, my lord. Ultimately, police went to his house, my lord, recovered 13 cattle without any documents or proper thing, my lord. Vehicle also, and he said, that is that.
Oh, then your case is not similar with the petitioner, other co-accused. The other co-accused persons we considered because except one high Honda or
Those cattles, my lord,
there was no recovery.
those
But here, where from you are saying, Mr.
From FIR, my lord. From FIR.
From the FIR. Oh, yes. So you are the mastermind.
No, I am not, my lord. These kettles are my kettle, my lord.
Huh?
My kettle, my lord.
All kettles are your kettle.
Yes.
Then it's okay, good only. Kettles are your,
I will
your
produce the document, my lord, if there is some
have you now
protection.
purchase documents? Have you annexed here?
No, no, no.
The cattle purchase document you have annexed here? No.
No, no.
Now you are saying that all the kettles you have purchased.
These are all not purchased, my own kettle.
Own cattle?
Yes.
He is saying
My lord,
his own cattle.
when he says, my lord, he owns that cattle.
Yes, I own
Ah.
this kettle. I am a
How many
farmer.
kettles? 13.
13.
I'm the farmer, my lord.
No. My lord, at this case, silly may be called for, my lord. Because the persons, my lord, not only co-accused statement, along with the statement, there are recoveries, unaccounted recovery.
Well,
Those are his
Initially-
cattle.
Initially, some persons were caught by
Yes, ma'am. 3 persons.
3 persons.
Three.
From them also there was recovery.
Yes,
Also.
my lord. My lord.
well,
And then they only name
I am
your name.
I am ready to cooperate with the investigation. Some protection, my lord.
My lord, from 3 persons, my lord, they were coming to purchase the cow from this person. From their vehicle, because in those areas this theft was going on. Then public apprehended them, recovered money, like 15,000, along with my lord, Bogha that rope, my lord, to tie the cow on the back seat of the car. My lord. Then they informed the public along and the police also that they came to purchase the cow from this person who is the main mastermind of this whole activity. And ultimately, police went to his house. 13 numbers of cattle were recovered. He was not there. He basically absconded. Also, 3 cars were also seized from him. This is the case. Because not only the co-accused statement, the statement backed up by the recovery. So that
And no cow was recovered from the spot. From my house only they have seized the cattle. All the
Now
matter
he
is
is
fixed.
saying that those belong to him, the cattle.
so why he ran away?
Why you ran a
No,
Plan away?
police will apprehend me, my lord. I'm going to.
Will come before?
Not
There's
only the
some
recovery,
protection.
not only the recovery, madam, because that police just blindly didn't went there. Police went there on the basis of a statement made by the other arrested person.
You are Mr. H.A. Ghosh?
Madam,
You are Mr.
S. Chauhan.
S. Chauhan. Mr. S. Chauhan. Your name is not
No, I'm on behalf of A.R. Som.
appearing on behalf of Mr. A.R. Shaw. Connected with the however, it is said that he owns some cats which were seized by police, those which were seized by that a party is no way connected. That context, Mr. Statement made in the FI seems that the presentation is the entire trial from whom the cattle were purchased by the co-accused person. The basis of statement made by the co-accused one, cattle were recovered. But at the time, the parents did not cooperate with the investigation. Then December. Of the body CDP call for when it can be listed.
Immediately after vacation.
My lord, this case is
Already fixed.
27th of January.
But 27 will be too long for you.
It's long.
We are trying to give you a short date. 19th of January will be.
Thank you. Right.
Made with your lordship. 482 bail application, your lordship.
Yes.
Allegation under section 69 BNS, your lordship. FIR page number 14, your lordship. Basically, the allegation is your lordship physical relation under a false promise of marriage, your lord. May I read the FIR, your lord? Your lordship, I, Molina Jensen Bem, respectfully submits this complaint before this honorable commission seeking justice and legal action against Mr. Mutum Bisal Chinna, who is petitioner, your lordship, Assam for sitting emotional exploitation and humiliation after gaining my trust and entering into a physical relationship under a false promise of marriage. Madam, I have been in love relationship with the said person since 20 September 2024. Initially, I refused his repeated request for physical relationship on several occasions, as I wanted our bond to be based on respect and genuine commitment. However, on 13 October 2024, after he emotionally pressured and blackmailed me to prove my love and repeatedly assured me of marriage, I trusted him and consented. Thereafter, we continued to have multiple physical relations based on his continuous assurance and promise to marry me. Sometimes he also forced to have a physical relationship with emotional manipulation. During this period, he also asked me to take contraceptive pills to avoid pregnancy. I agreed because I believed he truly cared for me and intended to marry me. We even lived together during the month of October 2025 in a rented homestay, sharing our lives as a partners. However, after he returned to his home from the homestay on 13 October 2025, his sister, who came from Gujarat, began to interfere and threaten me to end our relationship, taking advantage of some financial matter that arose during our relationship, which he had voluntarily helped me with. On 1st November, I even went to his workplace and requested him not to break our relationship and to clear misunderstanding between us. I also repaid rupees 17,000 through online payment in order to save our relationship. But from 2nd November 2025 onwards, he totally ignored me, blocked all communication, and refused to respond to any of my calls, messages. His conduct clearly reveals that he deceived and exploited me physically, emotionally, and mentally under a false promise of marriage, and later humiliated and discarded me after destroying my
Okay,
trust
then
and
what is
reputation.
your case?
Your Lordship, my case is, Lordship, that I have a love relation with the informant, Your Lordship, since 2024. Initially, Your Lordship, everything went well. But later, Your Lordship, the informant took financial help from me and my family members, Your Lordship. At the time of repayment, Your Lordship, the informant denied. When my sister, Your Lordship, asked for repayment, she denied, Your Lordship. And thereafter, Your Lordship, financial friction was started, Your Lordship. And thereafter, Your Lordship, she filed this false FIR, Your Lordship. Your Lordship, the relationship is deteriorated due to financial friction, Your Lordship, and family interference, not false promise of marriage, Your Lordship.
It's very hard to say, my lord. Otherwise, it seems well consensual that you are in a relation.
She admitted, Your Lordship.
But the thing is that whether it is financial transaction, which my learned friend has stated,
She admitted in the FIR, Your Lordship. Informant
nothing to
herself.
show here, my lord, at this stage. my lord.
Interim may be
Your good
allowed,
name?
Your Lord. It's
Your name
It's Suduri, Your Lord.
is
Suduri.
Chaudhary.
Finally, interim may be allowed, Your Lord.
R.R. Kaushik. Really done it. And there was dispute and only and when the sister of the sister of the petitioner asked for repayment of the loan which she was provided, the dispute. However, there is no false promise. Petitioner is still ready to accept this cooperation. It's made in the FIR and for insisted for hearing is sufficient. Okay, you will be under interim protection. Appear before the IO within 7 days and cooperate in the investigation.
Right, Your Lord.
We are fixing it on 28/1/2026 for this.
Much obliged, Your Lord.
Your Lordship, Senior Counsel Mr. P. Bora is on legs, Your Lordship. My lord may come and take it up after some time. Much obliged.
26.
May I please, Your Lordship?
Yes.
Lordship, kindly have a look at the Azahar at page 10, Lordship.
Page 10.
Lordship.
Yes.
May I read, Lordship? Most respectful submission is that I have been living in the house of Shahadev Mehdi at Aparbari, Amindao as a tenant for almost 11 years. While I was on duty between 12 p.m. and 2 p.m. yesterday, and also in absence of my nice at room, the cash money, ornament, one mobile phone, 2 ATM card, and also a diary were stolen from my room. This is the allegation. Lordship, how petitioner connected? Lordship, kindly have a look at page 4. Para 4, I have stated, petitioner before your Lordship working in a shop at Jalukpali. The owner of the shop purchased a mobile set and that was handed over to the present petitioner. I have stated, Lordship, kindly have a look at para 4. And police, while it was Lordship installed, police checked the number and the police behind the present petitioner. Lordship, kindly have a look at para 4, page 4. It was purchased by one shop owner, Lordship. I am no way involved in this case. And shop owner handed over me the mobile set. I have stated in para 4. Lordship, main culprit already arrested. Protection may be given. I will cooperate with the investigation.
But here, my lord, why this softener will give him the mobile out of the blue? My lord? And
He
then why, whether that softener has been arrested or not, we don't know. Because
What was about
No,
the
no.
stopper?
Soponar was not arrested. I will cooperate with the
my lord, otherwise, if he knew that this is a stolen mobile or this kind of thing, he could have gone and hand it over to the policeman.
shop owner handed over to me. I have installed and police track it behind me. I am before this.
It's
No,
unbelievable.
he is saying why Shopanar handed over you.
This is known to him.
Huh?
That is best known by the lordship shop owner. How I can say lordship? Why it was? But it was handed over to me for use, lordship, only for my use. So lordship protection may be given. I will cooperate with the investigation.
said that, my
And
lord,
if there is any material on this case, there my bail may be
my
rejected.
lord, he said that, my lord, after taking police came to the shop, he could have easily come to and hand it over to the owner. My lord. He could have told the owner that take it back.
Now, where is the mobile handset? Have you handed over? No. It is with you now, still now with you.
Lordship. Lordship, I will give it protection may be
Oh,
given.
it is still with you now.
Yes, yes.
That's why, my lord, these are
So you
unbelievable stories.
Lordship, I will deposit. I will deposit it to the police. Police may seize it.
My lord,
Lordship.
and the allegation,
Protection may be given.
the
I am
allegation
no.
not only the mobile, there are other materials.
But I am not connected with
Let
any
the
other
city-
material,
let the
only to
city
that
come-
extent,
let the
Lordship,
city come.
regarding mobiles. Thanks.
Let the city come.
No, suppose you are the on good faith, you may receive. We are not on that. On good faith, you may receive the mobile handset because it was given by you by the shop owner, isn't it?
Lordship.
But when you have come to know that the stolen one, police is searching for you after installing the mobile handset, then you could have returned the mobile.
That is
Now-
true, but how I
Yeah,
can
yeah.
how I can return Lordship? Otherwise, I will be arrested.
No,
That's
he
why.
can return to
That's
the
why.
owner. Owner.
I will be arrested. That's why I will return it to the police, Lordship. Police may seize it.
He can
I'm
return
ready,
to the
Lordship.
owner, my lord.
Lordship may record my submission. I will return it to the police.
Pardon, Mr. Allen. This is an application. It's submitted by Mr. Mohan. His his shop owner, where he works and purchased 1 second mobile which was given to the business. When he installed the mobile set, the police tracked and now searching. However, he is ready and willing to extend his cooperation with the eye and also ready to hand over the mobile handset to the police station for investigating, provided with could not hand over the mobile handset as their Mr. Kaushik. Not only the mobile handset but other materials also stolen from the house. And when he came to know about the mobile handset, came to know that it is a stolen mobile handset, he could have immediately returned it to the owner. Instead of doing this, he is still possessively stolen mobile handset. Accordingly, submitted that CD may be called for considering the interest submission. Or still cannot direction when still under its he will be under interim protection, handed over the mobile handset.
Lord.
28, 30, 20, 29-1.
Obliged.
Please, Lord. Allegations against us, my Lord, for homicide not amounting to murder. In fact, it should have been in 106, my Lord. Negligent driving, my Lord. There's an accident, my Lord. There are three collision now under the BNSS. There are two 106 part 1 and part 2, my Lord. Part 2 is, my Lord, if you do not report the police, then it's a non-bailable. And if you report the police, that is a bailable offense. Here the case has been registered under section 105, my Lord, and 248, 281. That is a rash and negligence driving, my Lord. If you Lordship kindly see, and the Annexure 10 is the FIR, my Lord. My Lord, the three cars has collided, my Lord. One motorbike has came, my Lord, and they have entered, my Lord. First, the first one has a altercation with the then the vehicle, dumper vehicle was going and it was run over the body, my Lord. This is now the what I have stated in paragraph 5, my Lord. I just kindly see the Ezahar, my Lord. At page 10, my Lord. It is most respectfully stated that on 28/10/2025 at around so-and-so, my brother-in-law Navakumar Talakdar was proceeding from home to so-and-so Pillika towards his workplace in Jorhat town on his Bajaj Pulsar motorcycles bearing register number so-and-so, and when he just passed through ISBT in front of Sonari Gaon Mosque, a dumper truck bearing so-and-so coming from the behind at a high speed and negligent manner hit him from behind. As a consequence, he died on the spot. Incident was so scary that my brother-in-law Navakumar so-and-so had been crushed under the truck and was scattered here and there also. My Lord, this is the basic allegations, my Lord. I am the driver, my Lord. My Lord will kindly see the paragraph 5, what I have stated, my Lord, paragraph 5, my Lord. I just said that immediately after the accident, my Lord, the people from the locality gathered. Some began shouting and narrating the conflicting version of the incident, leading to the chaos and confusion. At that point of time, the police arrived and tried to control the crowd and to find out whose liability it was to the death of the deceased person, as there was as many as 3 vehicles, my Lord. 3 vehicles. It was stated the deceased person at the first instance collided with a car, my Lord, and then came under the dumper truck, which is the petitioner was driving. It is stated herein that the police, after the controlling the crowd, seized the vehicle and dumper truck, and thereafter the petitioner was allowed to go to call the owners and dumper. Dumper was been seized, my Lord, and the owner also reported this thing. So I'm a driver.
Now it is under BNSS, it is bailable or non-bailable now?
It's a bailable. One is bailable.
106.
It's non-bailable.
Second is non-bailable.
Second is not bailable.
Part 2, my Lord.
But
So
here it is 10, not 106.
105.
5. It has to be in, my Lord, 106 actually, my Lord. It's an accident, my Lord. Russian negligence.
But what 105 is?
It's homicide.
Culpable homicide.
Homicides, my Lord. Not amounting to murder.
So registered under 105.
5, my Lord. So that is why I have come, my Lord. Otherwise, I shouldn't come, my Lord, before this honorable court, because it's a bailable offense over the 106. One is concerned, my Lord. So that is why I have stated, my Lord. Kindly see 106(1), my Lord. 106, my Lord. 1.
Well, perhaps there was 106 PI lesson, no? There is 106 advanced lesson.
No. 106.
Well, I think there is one direction one PI was filed regarding 106, our High Court. I think not today, there is a direction not to register case in 106, if I am not wrong.
Not to case, register.
No. That was
That-
not,
that was
170, that is an cases where Honorable Justice, so he has said 179 cases registered, my lord, which is, it's a case of 179. At that point of time, when CRPC,
recently 106 is was
that I don't know. But if your lordship kindly see 106, my lord, the causing death by negligence. Whoever caused death of any person by doing rash and negligent act not amounting to culpable homicide shall be punished with the imprisonment of either description for a term which may extend 5 years and shall also be liable to fine. And if such act is done in registered medical practitioner while performing so and so, second part is not so and so. Explanation. And next two, my lord, is whoever causes death, my lord. First, if your lordship kindly see the, my lord. Second is this, if we do not report to the police, my lord, then, my lord, two will be, my lord, non-bailable, my lord. So I fall under category of 1061, my lord. So as a driver, my lord, admittedly, my lord, and as per the FIR also, it said,
yes. My lord, here in PIL 74/2024, my lord. Ritumoni Deka versus Union of India.
PIL 74/2024.
Ritumoni Deka versus Union of India. Here, this honorable court directed the police to refrain from registering case under 1062, my
two,
106.
1062, my lord. Two is non-bailable, that is why, my lord.
Why refraining? Why?
There was a PIL file here, my lord.
No, what-
Because earlier what has happened, my
Yes,
lord?
direction, my lord.
Earlier what
Because
has
now there is two part, 106.
10662, my lord. 10, what has happened, my lord? Earlier, before IPC, my lord, there are, my lord,
304A was
4A was there. So 304 is a bailable offense. Now, in the BNSS, it has come as 106, giving two parts, my lord. So there is a PIL regarding 106, regarding non-bailable, my lord. So the court says that don't register with 1062, my lord.
Well, this
That-
was in that PIL was basically contended that my lord, this is a violation of Article 220 sub 23, my 20 bracket 3. But in that case, my lord, because no one can be compelled to give evidence against himself. That is the main issue in that PIL. So this on our honorable High Court division
Right.
directed to not to register case under 1062.
Two, not one, my lord. One.
here in the case, we simply go by the FIR.
My lord.
I think 105 ingredients is not there, I think, because it seems to be an accidental death. Otherwise,
Seems to be
without it is very
from behind. But the thing is that from behind he came. It seems to be accident. But this aspect, I think court below has gone through, my lord.
all
And
gone through.
gone through the last page of the petition, my lord.
Yes, a page.
Page 20, my lord. 20 and 21, last paragraph, my lord. A small observation, I don't know whether it will put on.
What is said that investigation is not completed. That is why my bail prayer is rejected. And that is what we know. Either legislature's intention is to this, my lord. Why? There is an accident, my lord. And
If I don't know whether this person or the driver of the dumper had any connection with the fellow who died, or whether we don't know, because otherwise 105 also there should be an intention. Otherwise it isn't seems to be accidental. But yes, there is an observation that the police is investigating. We are providing some interim protection. Let us see.
well,
The why it has been registered under 105.
it has to be a 106, whatever it may be, my lord.
Maybe my lord police are under impression that because of this order.
Yes,
Yeah, maybe.
that may be one confusion maybe. And information to police is also there that police already arrived there, I think.
Yes, that is my lord, but from FIR it doesn't look like.
Oh, yeah, it doesn't look like.
Doesn't look like.
As per your submission,
My
we
lord,
have.
it's on affidavit, my lord, I have submitted. This is what has
From
happened.
FIR it doesn't look.
Yes. But Mr. P. what we done it, senior
K. Sharma.
assistant investigation. Petition. The Kaushik done it, additional PPF in cities from applications. Seven. It's in. But. Petitioner.
Look, 102.
Petitioner. is
Okay,
that
play 102.
the driver of the vehicle truck and the allegation that he was driving in the direction and meant and hit the was but so and that it is the case sorry it's the petition that during at the time of incident there was 3 persons and this which car hit the motorcycle and according to case or registered 6 weeks and it is this earlier paid application was rejected by Children after the extent of the submission. Case may not be registered under section 106 because as there was a direction scope passed in here 74 of it asking the police officers to refraining the in registering a case under section 106 saying the from the case and it's to extend the interim he will be under interim protection.
Hello.
It will be listed on 29/06/2020 sorry 29/01 and you cooperate with the IO within 7 days.
My lord. Obligement.
Please, your lordship. Here in this case, lordship, in the cause title, the sections are wrongly typed. So lordship may go by the sections mentioned in the FIR, lordship. Lordship may kindly turn to page 13. May I read, lordship? সন্মানপূৰ্বক নিবেদন এই যে যোৱা 7/12/2025 lordship this date of incident is 7/12/2025 and FIR was lodged on 10th lordship তাৰিখে সন্ধিয়া 9:30 বজাত মোৰ দেউতা গুৱাহাটীৰ পৰা আহাৰ গাড়ীখন লৈ ঘৰলৈ আহি আমাৰ ঘৰৰ পদূলিমুখ পোৱাত ঘৰৰ গেটৰ সন্মুখতে গাড়ীখন ৰখি থাকে So this vehicle do not belong to the present petitioner, lordship. গাড়ীখনৰ গৰাকী বিচাৰ খুচৰ কৰাত হঠাৎ দুজন যুৱক আহি মোৰ দেউতাক প্ৰহাৰ কৰে। দেউতা লগে লগে চেতনাহীন হৈ বাগৰি পৰে। মুখমণ্ডল আৰু মুখৰ গুৰুতৰভাৱে আঘাতপ্ৰাপ্ত হয়। দেউতাই পিন্ধি থকা কোটটো কাঢ়ি লৈ যায়। উল্লেখ যে উক্ত দিনা আমাৰ ঘৰৰ ওচৰতে থকা প্ৰিয়দৰ্শনী বিবাহ ভৱনত বিবাহ অনুষ্ঠান চলি আছিল। আমাৰ সন্দেহ হয় যে উক্ত বিবাহ অনুষ্ঠানলৈ অহা যুৱক দুজনে মোৰ দেউতাক মাৰপিট কৰিছিল। আমি জানিব পৰা মতে, so this is important হৈছে, আমি জানিব পৰা মতে যুৱক দুজন ক্ৰমে মিলনপুৰৰ কৃষ্ণ চৰকাৰ আৰু মৰিকলঙৰ অশোক চৌহান. So আমি জানিব পৰা মতে, it is from their knowledge. And now your lordship kindly see that it is said that Ashok Chauhan is before your lordship. Now it is said Morikolongor Ashok Chauhan. I have given the Aadhaar card that your lordship will find at page 15. He is not from Morikolong, lordship. And it is admitted fact, lordship, I have in fact admitted in my petition that he was there to attend the marriage, lordship, but he was not there in the vehicle which is mentioned in the FIR, nor he has anything with the informant's father, lordship. He parked his vehicle in a different place where he was along with his family members, lord. And it is only on suspicion that these names were included, lordship. He will appear before the investigator and disclose every fact to the investigating officer. Probably at this stage, some protection may be granted, lordship, till receipt of the case diary, because he says, lordship, janibo pora mote. And in marriage ceremony, the number of persons were there, lordship, admittedly. And the vehicle which was parked in front of the gate, that do not belong to the present petition.
But they were named specifically. And the person, it seems, going by the FIR, he got serious injury.
Delay in lodging the FIR is there, and lordship, it is said that janibo pora mote. So otherwise, I named FIR, I would not have paid, lordship. But here only janibo pora mote. So how he came to know those things has to be seen by your lordship from the case diary. So if anything is found, lordship will reject. But at this stage, probably he may be protected. Only one person could Ashok Chauhan. And a delay of 3 days is there. In the FIR, it is said 7/12/25, and FIR was lodged on 10th, 9th, and registered on 10th.
It is submitted. The number which was stated to be parked in front of the house also does not be. It is the fact that he was also attending this ceremony, which is family member coming with his own car. There is no way connecting the arrest. He further submitted that from the FI reports that it was the name of persons are mentioned in the FI only in suspicion, but without any kind of other involvement. It's willing to accept. Reveals that the victim sustained serious injury. Importantly, it existed all for the victim. He will be under interim protection.
Lord. Obliged.
Appear before the IO and cooperate in the investigation.
Lord.
29(1).
Lord. Obliged. The sections mentioned in that page 14, that may be recorded in the order, lordship. I have already filed my IR, that will be listed next.
Oh, it is not yet come.
Not yet come. That will be, lordship.
FIR from
Page 14, that sections are there.
Oh.
Obliged.
May I please, your lord? 482 application, my lord. My lord, I take your lordship 24 page kindly.
File page number 24.
24, where a POXO case has been lodged by me for
came to my house and took me from my house to the residence of accused number 1 at Jhagrapara, part number 1, Dhubri. After taking me to the said house, accused number 4. Accused number 4 is the mother of accused number 1, lordship. 4 opened the door, and thereafter accused number 1, 2, 3 the three accused person forcefully committed rape upon me against my will. When I raised hue and cry, accused number 4 came forward and gagged my mouth with a cloth. After committing rape, the accused person forcefully obtained my signatures on 4 by blank white papers and wrongfully confined me inside the house. Subsequently, people from my family came and took me away from the said house, Lordship. The actual fact of the case, Lordship, the accused number 1 is a 27 years old boy, Lordship. He is a driver. By profession, he is a driver. And accused number 2 is a student. His age is 22 years old, Lordship. And I'm stated the actual fact, page number 4, para number 3, Lordship. The actual fact of the case is that the informant is a married woman who is above 30 years old, Lordship, and has 2 grown-up children. The informant and petitioner number 1 became acquainted with each other through social media. Thereafter, mobile number were exchanged and they started communicating with each other. However, the informant deliberately concealed the fact of her marriage from petitioner number 1. Upon coming to know about her marital status, petitioner number 1 immediately stopped all communication with the informant. The conduct of the informant thereafter became abnormal and obsessive in nature. On 2025, in the morning hours, leaving her children behind, the informant came to the house of petitioner number 1 on her own accord. When the mother of the petitioner number 1, who has falsely implicated as accused number 4 in the affair, Lordship, noticed the situation, she found the same to be inappropriate and advised the informant accordingly. The mother and sister of the informant was then called and a meeting was held at the house of the petitioner number 1. In the said meeting, petitioner number 2, who is merely a friend of the petitioner number 1, was also present as a well-wisher. After due counseling and amicable discussion, the informant was peacefully handed over to her mother on the same day. After 3 days, the informant was filed a false FIR, Lordship, against the petitioner, Lordship. And the delay of the reason of the delay of the affair is not mentioned in the affair, Lordship. And one order was annexed, Lordship, which is page number 17, Lordship. Petitioner number accused number 4, Lordship, who is the mother of petitioner number, was already granted pre-arrest bail, Lordship. So we want interim protection before your honor, Lordship.
My lord, it's a case of gang rape, my lord. Kindly peruse page 17 also. Here the last paragraph, my lord. So, after perusal of the CD and the statement, my lord, their petition was rejected. So at this stage, I pray for.
Only the section was mentioned in gang rape. That's the reason, Lordship.
It seems, my lord, the perusal is there. My lord.
Play has no mention, Lordship. It's a completely, Lordship, fabricated, Lordship. In anything found in the CD, Lordship, that time my interim protection may be vacated, Lordship, or rejected the bail, Lordship. But in the meantime,
It's a case of gang rape.
Yes, ma'am. CD will be required.
It's not a case of sexual rape against one person, or there may be consensual also relationship. I don't disagree with, because it seems that she is 30 years old. So she will be a married woman.
she's already married, Lordship.
That's what I'm saying here. It is not written as in whether she is married or unmarried, but she may be a married woman because her age is 30. So in that count, I can understand that she may be a married woman, but the allegation is very bad because it's a gang rape. One when she committed rape.
Lordship, interim protection may be given, Lordship. Then after whatever may be wrong in found in CD, Lordship.
That can be understood, but it's a case of gang rape. That's why. When it can be fixed. Obviously, after BU only.
Any date, man. Convenient to this court.
21.
After BU is so long time, Lordship.
So you are not on
Because
custody.
I'm not protected, Lordship.
You are not on custody, na? 21-1-6.
Much obliged.
For withdrawal from next item number 1.
May please, Your Lordship. I may be allowed to withdraw this petition, Your Lordship.
Actually, it was fixed on 22nd or 21, na?
On instruction, I am withdrawing this petition, Your Lordship. Doesn't know whether what could be the reason, I don't know, but on instruction, I am
Mr. Das in the morning hours, he said that there may be for consideration of charges framed.
He also told me that.
That kind of thing is submitted. Anyway, as per instruction.
Lordship.
You are Mr. S.A.
S.I. Borbu, Your Lordship.
Part Mr. S.A. Borbu. Done. Right. Okay, we are disposing it on withdrawal.
Lordship. Deeply obliged, Lordship.
Okay, yeah.
Option, no?
No, must be 21. NDP.
You have received this scan copy here or?
1-5.
I don't know. Close the tape.
Oh, 15. Scan copy, na?
So last occasion,
My lord,
the
office-
case diary was not there.
Office note, my lord. 612, my lord.
Office note.
612, my lord.
On the last occasion, what had happened? This case diary was not available.
My lord.
Yes.
For that reason only, we asked to call for the scan copy of the case diary also.
My lord. And
Otherwise, it is a charge sheeted case.
Charge sheet case, trial is already proceeding.
again, my lord, no steps taken. In the last part, my lord, it was my lord, office note, my lord. No step taken.
Respondent number, who is respondent number? It's a case of what kind of case?
It's an NDPS case.
Then why respondent number 2 is required?
There's
Is
no
there any
respondent
order
number 2.
taking steps?
No.
Respondent number 2.
My lord, perhaps not respondent number 2, only for the, my lord, CD parties, my lord. For that purpose, perhaps steps not taken.
No, they will take steps.
My lord.
Why they will
No.
take steps?
That also not mentioned in the, my lord, in the office note.
No, it is received that the scan copy of the case diary has not been received. That is there only. And further no steps. Why further no
Mine.
steps? Question of respondent number 2 does
Mine.
not arise here.
There's no correspondent number 2. The state is the
state?
party here.
That's true. Rather, they have not taken steps. She has not taken steps.
That
Maybe.
that may be my for the polling of CD, my lord. That,
Yes,
that
then
may
along with this scan copy of the
Mine.
case diary
Yes,
was
sir.
also called for because it is required, it is necessary to call for. As per you, the case, your charge has already been framed or not?
Already
yet
framed, already 3 witnesses were examined, Your Lord.
3 witnesses examined.
Examined, Your Lord. And none of the witnesses reveal anything against the petitioner. And so far the petitioner is concerned, the vehicle which was seized and from where this cough syrups were, banned cough syrups were recovered, that vehicle doesn't belong to the petitioner.
Where from he got arrested?
He surrendered before the court, Your Lord, under direction of Your Lord. Last, he surrendered on 19/4/2025.
Since about 8 months. he
Yes,
is there. Fantastic. From the the office note dated 6/12. The scan copy. The case there is received. It is seen that by order dated 28/11/2025, the registry was directed to call for the scan copy of the case diary along with the charge sheet. No. Oh, it was not there. Apart from the order, it also for submitting the status report that is run a trial court that a court did not make any inquiry in regards to non-availability of the case diary along with the charge sheet. So now what they are doing? A case charge sheet cannot be accepted without the case diary. Case diary has to be there.
Sometimes as per found the OC at present only relevant person is necessary for submitting, not the CD is required. Search sheet is required for send to the port to them.
No, charge
the
sheet
whole-
is there.
Madam.
Charge sheet is
As far as they have not OC not submitted case diary, that may be also.
then he can what happened for the corroboration,
Madam, that is
whatever.
Madam.
Your case diary will be required.
Madam.
From the case diary only you'll prepare your copies and all which has to be furnished to the applicant. Now how without CD, how a case can be proceeded? I just confused in fact. Acha.
Next.
Yes. Only the relevant one. So is the relevant one is available here? Because I'm not then. Someone had submitted that Mr. Busho was there and he submitted that CD is not there, and then from the it is then only I have passed the order that if it's not there. Now most probably he submitted that 161 or 162
No, that
are
may be
also not
possible.
available. I don't know what is this says. You can go to the record otherwise.
For that official is there.
Or 161 is available.
Is there with Nathan?
Anyway, how many witnesses were cited in fact?
There are altogether 9 euros, including the
Nine
official
wit-
witnesses.
9 witnesses.
9 witnesses.
Nine.
We already declared. And all these three are Caesar witness.
Declare. Is it? Record. Of submitted additional PP is that at present the IO used to furnish the relevant copies of the case diary, including the 164 and 161 CRPC statement of witnesses. Apart from this is a list of the relevant documents. But on perusal of the scan copy which is available within case record, it is seen that only 161 statement of 4 witnesses are available in the case record, and the rest of the witnesses are also witnessed. In view of this, the raised it is directed to call for the scan copy of the entire case record, including the statement of witnesses recorded in section 16 CRPC by police during investigation, and apart from that, the other relevant documents which was sent before the court at the time of filing the charge sheet. The scan copy along with all the relevant documents and the status report of the present status report of the case should be reached before this court on or before the next date of listing. The registry will issue remand according and we will do the need. It is the case from which place?
Nagaon, Your Lord.
Thinking of giving you 19, but better to give on 20, I think. The reopening day is 19. 19
Reopening?
is the reopening day after Bihu vacation.
After Bihu vacation.
Yes.
Can it be before
Before,
Bihu?
so we only 4 days left, almost full.
Can it be on 9th, Your Lord? It's
9th we are
Friday.
not. We have some difficulty on 9th. We'll be busy otherwise. Maybe on 19, not 19, in 20. Take it on 20 because 19 it may not reach also. Our look up the notice may be accompanied along with the copy of order by this court dated 28/11.
Your Lordship, 55 days behind bar, Your Lordship. CD was called for
Matlab, here CD is in the court number, matlab, 24.
24, Your Lord.
Right.
Connected is taken up by Lord.
And it today
Your Lordship, may I pray that Your Lordship matter be
we can, but I don't know whether it will be taken up or
because at 2 there are some other matters are
other
fixed, Your
matters are
Lordship.
there.
Yes, Your Lord.
The
Lord.
list required. Detail is required in order to get
Lord.
as what it is submitted by Mr. Shaw that the case diary is lying before the court number 20. In that context, Mr. Water submitted that the matter is the present case also may be sent for the same court where the CD is taken. The offices send the case. This court. Okay, we're sending it.
Lord, deeply obliged, deeply obliged.
Here the petitioner is in custody since 28 to 2023, Lordship. That is in February, it will be 3 years. And here in the FIR, the Lordship will find at page 15.
Since when you are saying in custody?
28 February 2023. Two years, 10 months.
FIR is?
FIR is at page 15. No one named in the FIR. It is said that some unknown persons entered the house and while looting the articles had killed the husband of the informant lord. That is the allegation. Now, your lordship will see that my involvement, they say, lordship, that there is a steel container in which they have found my fingerprints. In the charge sheet, it is said that your lordship will find page 32. There are statutory lordship that violation of statutory provisions are also there. I'm coming to that, but before that, just I'm pointing out the facts, lordship. Page 32, your lordship will see. Down below, your lordship will get. Okay. The 12th line from bottom, lordship. CIDৰ ফিংগাৰপ্ৰিণ্ট এক্সপাৰ্ট আহি ঘটনাস্থলীত চান্স প্ৰিণ্ট সংগ্ৰহ কৰে আৰু পদকীয়া ছাইদুৰ ৰহমান ৰফিকুল প্ৰিণ্ট জব্দ কৰা ষ্টীল টেমাৰ ফিংগাৰপ্ৰিণ্টৰ সৈতে ছাইদুৰ ৰহমানৰ ফিংগাৰপ্ৰিণ্ট সাদৃশ্য আছে বুলি ফিংগাৰপ্ৰিণ্ট এক্সপাৰ্টে অপিনিয়ন দিয়ে। So this is the fingerprint they are saying, lordship. Now, when this was recovered, lordship will kindly see that page 131. That is steel tema, they say, lordship, that page 131, lordship will see that this seizure, first paragraph I am reading, lordship, reference Jalukbari PS case number so-and-so, place of seizure, residence of Sanjeev Burman. So this Sanjeev Burman is not a witness in the present case, lordship. So from his residence, these articles were recovered. Date and time of seizure, 4/3/2023 at 3:10 p.m. And lordship, your lordship, in subsequent paragraph, it is held that it is observed that it is shown by Saidur Rahman. So this seizure list, they are saying prepared on 4/3/2023 from the house of Sanjeev Burman, on being shown by the present petitioner Saidur Rahman. Now that container list your lordship will find at page 135. Page 135, serial number 65. That is one steel box, lordship. That is what I have found. That is the word. So now they are saying it is recovered on 4/3. Now signature, your lordship may kindly see page 137. Signature is of 4/2/2023. These things were already recovered and this seizure list was prepared much prior to that, lordship. That signature page 137, your lordship will get 4/3/2023. But in page 131, they have written that 4/3/2023 it was recovered from the house of Sanjeev Burman. That Sanjeev Burman is not a witness to the present case. From the charge sheet also, I will show to your lordship that part. And this seizure list was produced before the magistrate, lordship. You will find that I have enclosed the vernacular in one page, lordship, page 142. That signature of the magistrate is there. 42, 43, and earlier part there are no signatures. Only in 42, 43, your lordship will get the signature. That is 6/3/2023 it was produced. Only that is the lordship incriminating material against the present petitioner, lordship. Apart from that, there is nothing. And subject to what my learned friend says, lordship, that 50A notice was not given to his relatives, lordship. And I have checked, and subject to what my learned friend says, it is not there in the record, lordship. And the other thing, lordship, I had observed in the earlier order that sufficient compliance is there. Regarding that, lordship, on that day also I have submitted a division bench judgment is there, our high court, that says, lordship, sufficient compliance will not do, lordship. That subsequently it is also held by the Honorable Apex Court also, that Ahmed Mansoori I am placing, lordship. And here, Lordship, one Ahmed Mansoor, subsequently that judgment also came. After that, our Division 1 judgment. Here also it is held that explaining by the magistrate will not suffice, Lordship, that written communication has to be there. Last paragraph I am reading, Lordship. In such view of the matter, Lordship,
Last paragraph.
last paragraph of Ahmed Mansoor judgment, Lordship. In such view of the matter, we are inclined to hold that the present appeal deserves to succeed only on the ground that the mandate of furnishing the grounds of arrest at the time of securing the appellant has not been complied with. Therefore, we are inclined. I'm sorry, Lord. Just. Yes. Therefore, we are inclined to go into the merits of the case. However, while setting aside the order passed by the High Court and consequently setting aside the order of arrest and remand, we would only say that liberty is granted to the respondent to take recourse to law to arrest if a case is made out. Suffice is to state that the explanation by the court before whom the arrestees are produced can never be an adequate compliance of furnishing the grounds of arrest at the time of securing an accused. So therefore, Lordship, that written communication has to be there, Lordship. And my second ground, Lordship, that 50 was not complied in the present case, that is not there in the record. And another aspect, Lordship, I'm on delay ground also I'm paying for bail, that your Lordship will find. Page 113, Lordship, may kindly have a look, Lordship.
Compliance of 50.
Page 113, Lordship. 50A, that relative notice to relation, that is not there totally, Lordship, at all. Lordship. And second ground, Lordship, I'm page 113, Lordship, may kindly have a look, Lordship. Page 113, Lordship, earlier order. Lordship. And here, last three paragraphs I am reading, Lordship. The learned trial court is hereby directed to expedite the trial of the case and to make all possible efforts to conclude the trial at the earliest, preferably within a period of 6 months from the date of passing of this order. So there was a direction by this honorable court to conclude the trial within 6 months. And that, Lordship, has passed yesterday, Lordship. That direction was given on 17/6/2025. This order was passed, page 103, starts from page 103. Now the trial is at same place, Lordship. That has not progressed. Just on this point, Lordship, I am relying on a apex court judgment, Lordship. In fact, in this, the judgment which I am referring, that relates to NDPS, Lordship, and there was rigors of section 37 was there, even though bill was considered, Lordship. Paragraph 4, I am relying on, Lordship. May I read? The investigation is complete. Charge sheet has been filed. Though the charges are yet to be framed, the conclusion of the trial will thus take some reasonable time, regardless of the direction issued by the High Court to conclude the same within 1 year from the date of framing of charges. The petitioners do not have any criminal antecedents. There is thus substantial compliance with section 37 of the NDPS. So here that direction was there to conclude the trial within 1 year. That did not take place. That was considered, Lordship. So these are my humble submissions. On merit also, Lordship, that except that container signature, container fingerprints, that Lordship, whether it was found from some other person, he is not a charge sheeted witness. That charge sheet also I have included, starts from page 20. Lordship.
Lordship.
In this case, I have already pointed out to your Lordship all the facts. Just I'm consciously pinpointing those points, Lordship, which I am raising in the present application. First, Lordship, that on merit, it was only the circumstance that it is the prosecution case that he's shown some articles to the investigating officer. Accordingly, those were recovered from the house of Sanjeev Burman. That Sanjeev Burman is not not a charge sheeted witness. And from that lordship container, his fingerprints is matching. So whether this container belongs to the deceased or not, those are matter of trial, lordship. So at this stage, probably that prima facie view lordship can take. That is my humble submission before lordship. And second thing, lordship, that delay already, lordship, he is in custody for 2 years, 8 months, 20 days. And there is no, and this present case is under IPC offenses. And there is no section like 37, the present case. That delay, lordship, may consider. And another aspect, lordship, that 47, that 50 and 50A, statutory lordship, that part, 50 lordship notice is given, but it is without grounds of arrest. And even if it is explained by the magistrate, that will not be sufficient, lordship, that I have given Ahmed Mansoori judgment. And second, also 50A, that is to the relative, notice to the relative, that is not at all there in the present case. And lordship, that last submission, lordship, that your lordship directed to conclude the trial within 6 months. That 6 months has passed, but the last witness was examined on 1st February 2025. And since then, lordship, no witness turned up in the present case, lordship. And total witnesses, 19 witnesses.
How many witnesses now? At
10.
Last witness was 19?
1st February 2025.
As a whole, witness number of witnesses?
19.
19.
19.
And how many of them
10.
examined?
10.
10.
10. And last witness was examined in the 1st February 2025. That is more than 10 months, and since then, no witness started.
Okay. Yes.
But here on merit, I will not argue, madam, because frankly speaking, I have not seen on those points because there are technical grounds which my learned friend has taken. Regarding grounds of arrest, my lord, here this case, the 3 years old case, my lord. And my lord, here I would like to submit that, my lord, in recently, your lordship knows, my lord, in Mihir Ranjan Shah. Ultimately, Supreme Court discussed all the Bihan Kumar and all the past, some conclusion has been given that he has to be given his grounds of arrest written his communication. But that one paragraph I like to point it out, my lord. That is paragraph 58, my lord. I have taken out from Indian Kanun, my lord, that we are, after discussing all those things, my lord, after giving that observation, paragraph 58, we are cognizant that there existed no consistent or binding requirement mandating written communication of the grounds of arrest for all the offences. Holding as above, in our view, would ensure implementation of the constitutional right provided to an arrestee as engrafted under Article 22 of Constitution of India in an effective manner. Such clarity on obligation would avoid uncertainty, administration of criminal justice, the end of fairness and legal discipline. Therefore, demand that these procedures are as affirmed above shall govern arrest henceforth. The word henceforth. So the court, after giving those observations, that these findings are given, my lord, that that it has to be given in this manner, modern manner that has been prescribed, that your lordship knows. After that, this court made this observation that henceforth these principles will guide, basically. Because prior to that, there was no binding requirement. This paragraph 58, my lord.
That's one copy I have given, lordship can have a look. I have given one copy.
Okay, paragraph in English.
That this is this is that hit and run case probably. Yes, that hit and run case probably your lordship remembers that your judgment was reserved.
Ultimately, here all those cases, because some questions were raised regarding the all this judgment, all are discussed and then these findings are given. Regarding my lord, it so far that observation that regarding conclusion at trial within 6 months, that is not a direction. That was not a direction, and to be, my lord, so far my knowledge board, this court cannot give direction to the board below to conclude that trial in a specific period. Supreme Court has made it clear. That was the order was endeavor shall be made. It was not that you finish within 6 months. The court has requested to make an endeavor so that this can be concluded within 6 months. So in that case, my lord, the witnesses were examined, my lord. And I have seen, my lord, some of time the court was not there, my lord, on leave. My lord. So it is going on in a good pace. 3 years, 10 witnesses has been examined. Regarding delay aspect, my lord, I will place one judgment of our High Court, my lord. I will not explain. I have given it. Here it is section 50 and delay. Those two aspects have been discussed. So my lord, and third thing is that, my lord, whether he has committed, not committed, because this lordship is taking up, my lord, bail petition right now. Lordship only see primary. These are matter of right. And regarding delay, I will also like to point out one thing, because this delay aspects were initially discussed in my lord Muslim model and all those things. There are two aspects. One, that prolonged incarceration, because every case has a different aspect. Because in some cases there are only 5 witnesses. If no witness has been taken for 6, 7 years or 5 years, it can be said it is delay. But if there are 100 witnesses and in 3 years 70 witnesses has been taken, it cannot be said it's a delay. So there are two aspects. One is delay and second is no possibility of concluding the trial. If your lordship sees all the judgment of Supreme Court, there are two aspects. Here already 10 witnesses has been examined. So in my humble submission, my lord, there is a possibility of concluding the trial within the court's time. So these are my basic submission. On merit, my lord, I will not argue because matter is going on, trial is going on. And your lordship's own judgment is also there. Here, lordship also said, my lord, regarding the gravity of the offense. Here also 47, 50 notice, 48 notices were not given. So here also lordship rejected considering the gravity of the offense. That point was also considered by the right in mind. So these are my one judgment also went on a similar line. They also gravity of the offense.
Well, Lordship, my submission for Lordship is that this Ubedur Rahman, this was already discussed in Lordship BA number, that copy I am handing over Lordship after that sometime. BA number 3039 of 2025 by coordinate bench Lordship. And the Supreme Court judgment has been relied to say that this is our constitutional rights and this cannot be Lordship violated. So it is already distinguished in that case. So that I will place before your Lordship. And second thing, Lordship, what my learned friend says that gravity of the offense, that when Lordship that constitutional rights are violated, then Lordship that merit of the case will not come, Lordship. And it is in Lordship in Bihan Kumar's case also, and Director of Enforcement judgment is there. That also copy I am handing over to your Lordship. That whenever Lordship it is said that the constitutional rights has been violated, the person has to be released on bail, Lordship. So then the merit will not come. That is my humble submission to your Lordship. Because in the present case, 50A notice is admittedly not there. It was not informed to the relative, Lordship. Apart from that section 50 Lordship contents. These two copies I will hand over to your Lordship. That Director of Enforcement and BO. In fact, Lordship, just one thing I'm sorry to point out. At page 147, Lordship, I have given one documents, Lordship, which I could not give it earlier, Lordship, that it is part of the case diary.
147.
147. The initial case was that, Lordship, some other persons were involved. It is reflected in this case. The person who, Lordship, the miscreants, they stayed in his house. They admitted before him. Those persons are not there now in the picture.
Some miscreants were staying.
Other miscreants, Lordship, other persons named in these documents, Lordship, though they have committed the offense. It is clear, Lordship, may kindly have a look at 147 for a moment.
What it says?
I'm just reading in Assamese language, Lordship. It is. মোৰ নাম ও ঠিকনা ওপৰত মতে সত্য মোৰ বৰ্তমান বয়স 32 বছৰ মোৰ আচল ঘৰ বিজয়নগৰত মই নিজে বঙৰাৰ ইছলামপুৰত মাটি কিনি পৰিয়ালসহ তাতে বসবাস কৰোঁ মই গুৱাহাটীতে কাম কৰাৰ বাবে গুৱাহাটীতে ভাড়াঘৰ লৈ থাকোঁ যোৱা ইংৰাজী 9/4/22 তাৰিখলৈ মই তেতেলীয়া গ্ৰীণভিউ কলনীৰ ওচৰত এটা ভাড়াঘৰত আছিলোঁ উক্ত ভাড়াঘৰতে মোৰ বন্ধু মুকালমুৱাৰ বক্কৰ আলী আৰু উছমান আলী দে আৰ নট চাৰ্জচিটেড লৰ্ডশ্বিপ উছমান আলীৰ লগতে বৰপেটা পালহাজীৰ ৰুস্তম আলী আহি মোৰ লগত মোৰ ভাড়াঘৰৰ ওচৰতে অজিত চেতিয়াৰ ঘৰত চুৰি কাৰ্য সংঘটিত কৰাৰ আঁচনি তৈয়াৰ কৰিছিল মই সিহঁতক মানা কৰিছিলোঁ যদিও সিহঁতে মানা নাছিল সেই আঁচনি মতে যোৱা 9/4/2022 ইংৰাজী তাৰিখে নিশা 12:30 মান বজাত সিহঁতে অজিত চেতিয়াৰ ঘৰত চুৰি কাৰ্য সংঘটিত কৰে মই সেই সময়ত মোৰ ভাড়াঘৰতে আছিলোঁ চুৰি কাৰ্য সংঘটিত কৰি সিহঁত মোৰ ভাড়াঘৰলৈ ঘূৰি অহা নাছিল পুৱতি নিশা মই উছমান আলীক ফোন কৰাত সিহঁতে অজিত চেতিয়াক হত্যা কৰা বুলি মোক জনাইছিল তেতিয়া মই ভয়তে মোৰ ভাড়াঘৰৰ পৰা পলায়ন কৰিছিলোঁ এই লোকসকল গুৱাহাটী মহানগৰীত চুৰি ডকাইতি কৰে বুলি মই জানো সিহঁত বহুবাৰ চুৰি ডকাইতি কেছত জেললৈ গৈছে মই কিন্তু আজিলৈ তেনে কাম কৰা নাই So these are the persons who committed that Bakkar Ali, Usman Ali, Rustom Ali. And this present person also that Moznur Ali disclosed all the facts to the police and those persons are not there in the picture now. Probably these persons may have been, I'm not saying that they are. Probably they have purchased those articles, probably that may have lead to their implication in the present case. But the actual culprits are that disclosed in the case diary itself. Obliged. I have given those judgments through email.
Yes.
Obliged.
Right, please, Your Lordship.
Yes, here we have received it. Is that?
Yes, there is. Yes, there is.
Yes, Mr.
Lordship, pursuant to the interim order passed by Your Lordship, I appeared before the IO and got my statement recorded, Lordship.
How many petitioners? Only one.
Only one petitioner, Lordship. And I am cooperating with the investigation, Lordship. Allegation, Lordship, you kindly find the FIR at page 9. Relevant portion, page 11.
Means it was the subsequent bail application.
My lord, earlier it was rejected, my lord. After going to the case date, my lord. Thereafter, again, it's filed their bill, my lord.
Only the considering the ground of pregnancy.
My lord, they want what?
So now what do you want to submit?
Lordship, I have appeared my statement recorded, my lord, and I am cooperating in the investigation, Lordship. So, my lord, whether my custodial interrogation is required, Lordship, because I am already cooperating, Lordship, with the investigation. Statement also recorded, Lordship.
Yes, yes, sure.
My lord, here the matters remains the same, my lord. Only thing is that he was granted interim visa, my lord. Wife on this one, my lord. And other things are remained the same in the case, my lord. After interim, he has appeared statement recorded.
But after interim, he appeared statement recorded. It's okay. Otherwise, interim incremental matters were there.
There are enough.
My question is that after his appearance, his recording of statement, what the IO says, whether there is any custodial interrogation will be required at this stage, or it may not.
Not mentioned here. He said that, my lord, he has appeared as per order of the Honorable Court, my lord. And There is no such, my lord, any IO note, my lord. But
Is there any bail objection to that regard?
okay,
Not as such.
no, that.
But Mr. MI regard. This is an application under section so and so. Is there a receipt? Pursuant to order dated 13/11. Petition has already appeared before the defense. And thus he is also cooperating in investigation of this case. However, he is still ready and willing to extend his he is extended with privilege of pre-arrest bail. Mr. Shroptail and additional PP that CD repeats payments against him on the basis of which his earlier bail application was rejected. Obtaining the order of interim pre-arrest bail, he appeared before the IO and cooperated in which reveals that the accused petitioner appeared before the IO and state there is no whether his custody interruption will be required, and that the party is objection by the IO. Considering all these aspects of the case, the interim bail granted to the petitioner dated 13/11/2025 is hereby made absolute with same terms. They have
Deeply obliged.
Mine. I have already informed our office regarding that the state already taken by now.
On lordship,
15 days.
Lordship, simply date of judgment. Lordship.
এবার আপনারটা যেতে দাও।
17.
না, কি করা? Yes, yes.
Oh, let's case. Oh, yes, case too much. Check for FIR. ঠিক আছে।
Mile. 8 mile. 8. 9. 9.
Obliged.
Mile.
Obliged.
May it please your lordship. Lordship, this is a criminal petition against order of the Learned Trial Court, wherein the petition under section 348 of the BNSS was dismissed, lordship, for further cross-examination, lordship. Lordship, probably service not complete, lordship. 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 Lordship.
Apart Mr. P. Borden, learned counsel So far, Mr. B. Sharma, from the office note dated 10/12/2025, it is seen this service is still awaited for the respondent. Let the service be awaited till next date of listing. Matter. We want any fixed date here?
Lordship, on 9th of January, Lordship.
Now see 9th, for and some reasons I have fixed that case on 9th.
Man.
But we are avoiding fixing on 9th.
Mhm,
because
well,
we have
several
some
cases are
meeting-
already-
No, we have meetings and all on 9th. We may not be in a position. So maybe immediately after Bihu will do.
Lordship, then Lordship after view any date. Lordship. But
Ah.
proceeding is going on trial court, Lordship. That may be state, Lordship. So, Lordship, after view,
Is
immediately
diary
after
also required here?
Trial court record.
trial court
Trial
record,
court
Lordship.
It is also not received, I think. or
Lordship,
received?
not received.
Not received.
Trial court record is also not received, as we will from the office. PST have directed to issue reminder for calling the trial court. 19th?
Lordship. Oblige, your Lordship.
Packet number 30.
Yes. Is on receipt, to receipt?
Yes.
May it please your lordship.
Yes, Mr. Biswas. Why are on busy today?
My lord, I am in Silchar, my lord.
Huh?
I am in
Silchar?
Silchar. Yes, yes.
For case purpose or hometown?
Case. I appeared in a matter today morning in Silchar.
Anyway.
As the saying goes, my lord, all is well that ends well. So this is the last case of the year I am appearing. My lord, your lordship, if remembers, my lord, the other day when this matter came up, my lord, it is a case of shown arrest. And your lordship will find the order of shown arrest at page number 24. Page 20, it starts from page 23 because the petitioner's name does not figure out in the FIR only because some person might have taken his name and which is why he has been shown arrested in this case. It is a 60 days offense and as on date 42 days he is already being in custody. And
42 days.
42 days. Considering the length of detention, your lordship was obliged to your lordship had fixed it today. Now, your lordship will see, though the prosecution has sought for some 8 days police remand, but the learned court below has not given a single day remand, which is evident from a reading of the order, which is at page 23.
No, but that day also you have submitted, but there is a on third para, I think, there's an observation that IO showing the above accused person arrested in connection with so and so, therefore allowing them police custody for the said accused persons. So we are not in a position whether those persons were on police custody or not. You are saying that they are not.
It is a prayer.
Order doesn't say so anything in regards to the remand, but there's a observation that police prayed for in custody.
It is custody.
But
Now, my lord, let me assume for a while. That on 7th of November 2025, 8 days were sought, and let me assume that this entire 8-day custody was given. Even then, my lord, we are on the 42nd day. And my lord, no fresh remand application has been. Bir Lachit Hena, my lord, those sweeping sort of, my lord, because the government came down on this organization. So whosoever even remotely associated, they all were booked. So that purpose is solved, my lord. Now, my lord, no such complaints is coming up from any quarter, my lord. But be that as it may, my lord, I am only because for the purpose of investigation, perhaps, my lord, in my respectful submission, but his further detention is not required, my lord. 42 days, my lord, 60 days offense, whether they have done, and not even FIR named, I can show the FIR, my lord, which your lordship may see at page number, it's a longish FIR, page 9, well drafted. And the name of the accused person appears at page number 15.
My lord, here in the morning hours also when my lord, I informed that my lord CD is court number 24, my lord. Here in this case, my lord, some analogous matter are going on in the court number 24, my lord. Today, that's why I am not in a position to argue anything, my lord. SCD is available in court number 24, my lord. Item number some same CID case, my lord, 20 oblique is going on, my lord, in the court number 24, my lord. CD is
Now, my lord, to whatever little I have understood from practicing in this High Court, when similar matters are posted before two benches, then the CD is ideally to be produced before the senior bench. That is what I have understood in my term of practice, my lord.
that is not
Now,
the case. CD is lying in the my lord, chamber.
Since earlier.
Chamber, my lord, earlier, my lord.
or
Just earlier.
chamber, that is odd. If it is in chamber, then my lord, I have got. But if it is listed, if the matter is
no,
listed,
perhaps in the it was lying on my lord. 1812. It was fixed on 1812, my lord. CD.
Matter was fixed for 1812 CD.
My lord, CD. Yes,
So they have received the CD.
my lord, in the court, my lord.
so day before yesterday, when the submission was made that will produce the CD, and when today in the cause list, the similar matter is placed before a senior bench, the public prosecutor ought to have made some effort to produce it before the senior bench. That is what we have understood, my
It
lord.
was fixed earlier, fixed on yesterday, my lord. 1812. Then
Yeah,
CD
yeah.
is there, my lord, from 1812. Just kept in the court, my lord.
My lord, in my understanding, my lord, perhaps, my lord, for
Some matters are there. Item number?
46 in code number 20.
Item number
46.
46 in code number 24.
that is precisely what I submitted. When cases pertaining to the same FIR is placed before two different benches, then the case diary should ideally be produced before the senior bench. That is what we understand, my lord.
No, it was
Even
lying
for
from
mentioning
yesterday, my
also.
lord. Yesterday also some matters are there, my lord. Then CD
No,
is
yesterday
as per
is
information
gone.
from our office, my lord.
Yesterday
For
is
information, it
24
was
hours back.
related, my lord. 18, it was taken in the court, my lord. 1812, my lord. CD in the court number 24.
Today morning also some effort could have been taken because it is
No,
placed
it
before
is
a
not
senior
our
bench.
duty, my lord.
The case diary production is the duty of the public prosecutor. Defense counsel cannot produce case diary.
When two cases are in two different courts, my lord, how public prosecutor will run from one court to another court, my lord, to collect the CD, my lord.
My lord, those type of excuses can well be given, my lord, but it is a handshake distance. Court number 24 perhaps is in the same floor.
It is not
It is
my
a
duty.
handshake distance. Now, my lord, that I don't have an answer to this.
My submission is that CD not available at here, and CD is lying in the court number, my lord, 24.
That is precisely my submission, my lord, because the day before yesterday also.
One I guess any. One I guess.
Now, daily is 36.
Okay, then there should not be any dispute in the order. Passing by the one court view may be another, my court view may be another, so that should not be. That's why immediately we are sending, just have 10 minutes, sending the.
So now I'll have to, because I am in VC, so I'll have to argue in court number 24. It will be a bit difficult, my lord, on my part, because
Just try,
I'm on.
make a request there over 24 because as per information given by the council from your side,
Yes.
it
Yes.
has not been reached till now. So it may reach. So
Absolutely.
just yes, immediately within 10 minutes we are sending.
I'm so deeply obliged, man.
That orders immediately made.